Welcome, everybody. Please come in and take a seat. I have to say it gives me great joy to see so many old friends, and I know that many people want to chat with each other, but we have some important work to do. So thank you all for getting settled. My name is David Wilkins. I am the faculty director of the Harvard Law School Center on the Legal Profession, where I have been studying lawyers in the legal profession now for, I'm a little embarrassed to say, 40 years. And I have to say, I've never seen a time like this. And there's never been a moment like this when we needed the kind of discussion which we're having today. I'm here mostly along with our terrific partners at the American Academy of Arts and Sciences, whose beautiful space we're now standing in or sitting in now, as well as Equal Justice Works and Verna Williams, who you'll hear from in a minute, and Kelly Testi, the president of the American Association of Law Schools, to welcome you to, I think, a critical conversation on inequality, access to justice, and the rule of law. I don't think I have to tell you that this discussion could not be more timely. We actually began planning this way back in the fall before we even knew the results of the election. But since January 20th, the Trump administration has taken or threatened to take a whole series of actions that raise serious questions about all three of the topics that bring us together today, whether cuts in government programs that threaten critical support for the most vulnerable, to trade policies that threaten to impose a regressive tax on, again, the poorest Americans at the lowest end of the income scale, to attacks, quite frankly, on the right to counsel and the independence of the judiciary that go to the fundamental idea of the rule of law. But it's important to recognize that the issues that bring us here today go back decades and are not about any particular administration, Republican or Democrat. Indeed, the very fact that so many Americans feel that the American dream is out of reach for them, that they don't have access to the fundamental aspects of the rule of law or basic economic freedoms is part of what's fueled, quite frankly, the moment that we are in. And it's therefore critical that we focus on these broader issues that move beyond today's partisan gridlock if we ever hope to make progress on it, which is why we are so grateful to the Academy for co-hosting this event for us. To be honest, when Verna, the newly installed president of Equal Justice Works, who I'm also proud to say is my former student, and I talked about this, we thought of a more traditional gathering, one in which we would convene thought leaders and heads of important organizations of lawyers who are working directly on access to justice issues. This is a subject that, as the Center on the Legal Profession, we are quite familiar with the issues and are quite engaged in trying to think about them. And we were, quite frankly, thrilled to be working with Verna and Kelly and others about thinking about these issues. But the more we thought about it, we thought we had to go beyond this. That is, you will see, we will focus on core issues around access to justice, and we have a terrific panel that David Engstrom is going to lead off with some brilliant opening remarks and a kind of panel of experts. And we're going to think about those core issues. And tomorrow, we're actually convening a sort of a closed-door working group of about 30 experts, many of whom are in this room, to try to drill down on these issues and to see what progress we can make. And we're particularly honored that at that gathering and this, we are joined by David Levy, who all of you know in his work. I'm sorry, John Levy. David's his brother. As I know the whole family. Sorry, John. John Levy, whose work as the chair of the Legal Services Corporation has really just been pivotal at keeping the government's commitment and our public commitment and public-private partnerships to access to justice alive. And quite frankly, on the 50th anniversary of the Legal Services Corporation, which we should remind everyone was under the Nixon administration and was the product of a bipartisan consensus, there's no better person that we could have here to share this discussion than John, although David would have been great too. But again, these issues, as important as they are, have to be located in the broader context of issues around inequality, access, and the rule of law. And again, this is something that we at the Center on the Legal Profession have always believed in. That is, for the last 40 years since I've been involved in these projects, we have tried consistently to convene a group of interdisciplinary scholars from fields as divergent as economics and anthropology and sociology, some of whom are in this room, to computer science and more recently design thinking, to try to work with practitioners from a broad range of professional disciplines, not just law, to share ideas and insights and best practices about how to move forward to those issues that lie at the increasingly important intersection of law and public policy and economics and technology and sociology and all of the rest of the important disciplines that go into understanding where we are as a country and a society today. We have a number of projects around these issues. We just completed an issue of our new digital magazine, The Practice, on the role of lawyers in promoting and resisting autocracy. We're looking at the development of legal professions around the world, particularly in emerging economies and rising powers in Africa and Latin America and Asia. We're trying to think through how can we understand the implications of artificial intelligence and new technologies on professional practices of all kinds and those we serve. How do we think about complex decision-making and making new frameworks for that decision-making in a world that is increasingly volatile, uncertain, complex, and ambiguous? How do we think about educational debt that is skyrocketing for our students and the challenges that many of our students and professionals face in integrating their work as professionals with their responsibilities to childcare and parental responsibility and other important aspects of their lives. And as we think about this topic in particular, we have for the last several years helped to incubate and to launch a brilliant initiative by my colleague Jim Greiner, who will be speaking at our meeting tomorrow, which he now calls the Access to Justice Lab, which seeks to apply rigorous methodology, often taken from medicine and the sciences, around randomized controlled experiments to understand what does and does not work in terms of interventions with respect to access to justice. And we were just last year hosted the biannual meeting of the International Legal Aid Group that brought together literally 100 academics, policymakers, practitioners, heads of legal services organizations from around the world to share ideas and best practices about how to make progress on these issues. As I said, you can find out more about these projects. We'd love to engage with all of you on our website at the Center on the Legal Profession, where you can subscribe to for free to our digital magazine called The Practice, which seeks to bring rigorous academic research, discussion, and debate in a form that busy practitioners and academics from a broad variety of disciplines can digest and relate to. All of this is particularly critical today as the legal profession and all the other parts of our society are being transformed by large trends like globalization and the increasing importance of the global South and East, or the rise in the speed and the sophistication of information technology and artificial intelligence and all sorts of new technologies, or the challenges which we see in our own country but are not unique to our country, to democratic institutions, to independent legal professions and judiciary and the rule of law. All of these areas are creating a kind of an explosion in the amount of law and regulation and risk that all actors and governments face in our society. And yet, law is only a piece, and in many respects, not the most important piece, of how we need to think and understand and work through these critical challenges. As a result, we need lawyers, and we need to be training lawyers who understand what they do is more than simply just reading and digesting and working through the law. They have to think of themselves as being a part, but only a part, of working collaboratively with professionals and policymakers and people on the ground and academics from a wide range of backgrounds and disciplines to try to create creative, new, integrated solutions for the problems that we face. The one thing we know for sure is that whenever we come out of our present moment, we're going to have to not just rebuild, we're going to have to reimagine our institutions, the role of government, the role of civil society, the relationship between the public and the private sectors, between professions, between academics and those we teach and those we serve. The issues we face today in this area are really indicative of this need. That is, as we'll hear in a moment from Jason Furman, the broader issues around inequality of income, around lack of affordable housing, around access to medical care, around education, around communities that have been hollowed out both in the inner city and, quite frankly, in rural areas around this country, are obviously generating huge amounts of legal need for people who find themselves in the throes of these kinds of problems. And yet these are precisely the people who don't have access to that kind of legal services, legal representation, or tools of any kind to operate and work their way through the legal system. And that, in turn, contributes to the very problems, because it's hard to hold government officials responsible. It's hard to get your rights recognized, which then leads to a kind of vicious circle in which the larger structural realities reinforce the problem of access to justice, which in turn reinforces and accentuates the problem of legal need. To break through this vicious cycle will require lawyers, policymakers, advocates to work collaboratively with the brightest minds from across the academy and elsewhere to develop new approaches and new ways of thinking that actually help us to reimagine not just the solutions, but the problems themselves. And to move forward in a way that has always been the hallmark of the best of this country's innovation, whether in politics or the private sector or education or whatever. We need that kind of spirit of creativity and ingenuity to address these problems. And frankly, there's no better place to try to cultivate and tap into that spirit of ingenuity than right here at the American Academy. Since its founding in 1780, this learned society has been dedicated to bringing together academics from across the spectrum and professionals and leaders in business, in law, in government, in healthcare, in every field of endeavor to address the most pressing problems of our time. In fact, I was just talking with some of the members of the Academy as I came in here, and we were talking about John Adams as the founder here. And of course, John Adams is uniquely relevant to issues we're thinking about today. Since as Justice Marshall, who is joining us here, knows more than anybody, that it was John Adams who agreed to defend British soldiers after the Revolution and established the principle that representing those who are most despised against the government is one of the highest callings of the profession. It's something I hope that we can all remember as we talk about these critical issues today. So we are thrilled that the Academy's president, Lori Patton, will be here with us later on today, and you'll hear from her later in the day. But before we do, we have really two terrific panels. One that is focused on these broader issues of inequality and access and the rule of law that we will get to in just one moment. And after a break, we'll have one that, again, as I said before, focuses more particularly on the issues around access to justice and our legal system. But before we get to either of those things, we are really delighted that Justice Goodwin Liu, who, as most of you know, is really a leading jurist in this country, a member of the California Supreme Court, who has also been a very productive and engaged scholar, including while his time on the court, and has written eloquently around issues of access and opportunity in the legal profession, but is now serving as the chair of the board of the American Academy, has agreed to give us a few opening remarks. Goodwin wanted to be with us here today, but for reasons that he couldn't control, wasn't able to, but said he would Zoom in with us. And his face, Goodwin, you're a giant, beautiful portrait of you. We are all admiring here to offer us some welcoming remarks from the Academy. Justice Liu.
David, thank you so much. It's my honor to say a couple words of additional welcome to to the Academy. Thank you so much, David. Whenever David Wilkins is chairing an event, you know it's going to be a high-octane affair. So, and I think your opening remarks were just spot on. So thank you, David. It's wonderful that you're doing this, and always an honor to be affiliated with you. I have only a few things to say that will amplify what David has already laid out. I think we don't need to look very far in the headlines to see that the rule of law is being tested in America today in ways big and small. But in many ways, I think, long before this particular political moment, the rule of law has always been tested in America, particularly for low-income people and people who are on the margins, for whom the law on the books has never been exactly the law in reality. And the gap, if you want to call it the justice gap, right, has always been with us. And so this effort is something that is very, very central to the Academy's outlook as an organization devoted to the rule of law. And we couldn't be happier to be partnering with the Harvard Center and the legal profession for this. So, three quick points. The first is that in the overall frame, this is not just an issue about the legal profession. And that is self-evident from the array of people who are gathered for this event today. But I want to begin by noting that, the Academy's own work on this, which has been so ably led by John Levy and Martha Minow, who have been extremely capable co-chairs of our Access to Justice work, has from the beginning adopted the frame that this is an issue for civil society. Lawyers, judges, yeah, sure, we're going to play a very, very important role at the kind of epicenter of the legal system. But I think anybody who has studied this set of issues will tell you that no amount of pro bono work, no amount of work by just people within the legal profession is going to make a significant dent in the justice gap that exists in America. It is just that big. And so we really have to think outside the box of the legal profession, nonprofit organizations, parallel institutions to government, the private sector as well, in order to marshal the requisite degree of resources that would even begin to give low-income people, and never mind middle-income people who are also in need of legal services, the support that they need to navigate our increasingly complex world. Second point is that in the overall framing, this has never been just an issue about strictly legal disputes. Of course, child support, debt collection, foreclosure, access to benefits. In their kind of microcosm, every one of these is individual dispute, pitting, sometimes an individual against government or individual against another organization. But as David Enstrom, I'm sure, will explain when he talks about his really outstanding project for the American Law Institute on high-volume civil adjudication, this is also about markets. This is about how our economy is structured, right? Because the economy is based on legal rules, and the legal rules are only as good as their enforcement of them by actual people who have access to the resources necessary to put legal rules into practice. And so, consumer debt, foreclosure, just to take a couple examples, are heavily structured by the degree to which ordinary people can actually enforce the rights on the books. And that shapes the way in which those markets work. And it's also why the Academy's Commission on Reimagining the Economy project highlighted as one of its recommendations greater access to civil legal justice. That's part of an economic report, right? So I just want to kind of highlight that important framing. And then the third thing I want to say is that it's impossible probably to think about any comprehensive set of initiatives or solutions to this justice gap without involving technology to some very significant degree. And I'm saying this as someone who is personally a bit of a Luddite myself. I'm not even on social media. I mean, that's, I have the excuse, I'm a sitting judge. So I'm not on social media. So I'm not savvy to the ways of the world in terms of technology. However, from an efficiency standpoint, I think some of the gains that are available should be explored. But even more importantly, I think, is just that this is the way of the world in which how people interact with systems, right? And so if we hope to kind of meet people where they're at in terms of user-friendly interfaces, and the legal system is not exactly known to be, the chief innovator of society, but if we hope to be able to deliver justice at retail, en masse to people, it is very hard to think that any possible solution to that isn't going to involve some degree of technology that kind of meets people in terms of their habits, user patterns, the way in which they interact with the world, which necessarily involves a great deal of technology. I'll leave it to the many entrepreneurs among you and the innovators among you to be thinking about that. And I don't wish to fetishize technology. There are many challenges involved in it, but I think the pandemic actually gave us a good set of experimental initiatives that many courts did undertake. And we should be thinking about those in terms of very ordinary transactions that people have to do through the courts and how they can be facilitated without people having to, take an entire day off or miss a day of work or arrange childcare, which they don't have. All of these things I think can be in many ways helped along by technology. So I'm going to stop there, and I so wish I were able to be with you today because this issue is near and dear to both my day job, but also to my personal passions. And many of you I know who are at this conference are my friends, and the rest of you are people who I want to be friends with. So I look forward to the proceedings from this event today, and wish you very well in your deliberations. And thanks for including me.
Thank you so much, Goodwin. We wish you were here too, and you can see why, right? Those just very brief opening remarks shows Justice Liu's breadth and his understanding of really the critical moment we're in and the open-mindedness that we have to have as we think about these things. It's also a perfect introduction to our first speaker. The way we're going to do this panel is that Jason Furman, who almost needs no introduction because already today I think he's been on 16 different radio shows or talk shows, most of which you should if you haven't seen. But he is the Aetna Professor of Practice of Economics and Policy jointly at the Kennedy School and the Department of Economics, and also the 28th Chairman of the Council of Economic Advisors under President Obama. And he's one of the most thoughtful and articulate people speaking about how these broader issues are reshaping our society, and even more importantly, and this is something we talked about on our call together to get ready for this, how we should be talking about them in a way that's galvanizing and not sapping of our energies, which I think is critically important today. Jason's going to speak for about 20 minutes or so, and then we have two terrific panelists, and me, but two terrific panelists who will engage in a kind of conversation around the issues that Jason has raised. One is my dear friend Arnie Duncan, who I have to say I knew when he wasn't tall and when he was just learning how to play basketball, and I would try to take advantage of him, but then that quickly ended. And as most of you know, went on to become first, the head of the Chicago Public Schools, one of the most complex and difficult managerial jobs in the world. And then President Obama picked him not only because he had a mean jump shot, but also because he really has thought more about education than anyone else to lead the Department of Education, which he did for all 8 years of the Obama administration. He now runs an incredible nonprofit whose acronym is CRED, which if you're cool enough to know why that's important, but it stands for Create Real Economic Destiny, working with inner city kids around issues of gun violence. The other is somebody I've known almost as long and who has had more to do with whatever success I've had in my career than almost anybody else in the world, and that's my dear colleague Martha Minow, another Chicagoan. You may get an idea. We stacked it with the Chicago Mafia, vote early, vote often, after all, is our view. But Martha is, as everybody knows, a university professor here, a leading exponent on all sorts of issues from family law to democracy to diversity to democratic discussion. She's written extensively on a whole range of issues and is currently working on what will be an incredibly important book around how we re-engage our politics in this moment. So, Jason, please come and give your remarks, and then we'll bring the panel up and we'll speak. Thank you. Jason Furman. Thank you.
So David, thank you so much for including me here. I'm an economist. I know a less than average amount about law, and the reason for that is my brother is a federal judge, and I figured I never needed to learn it myself. He does that half of the family business. I want to tell you, first of all, the narrative on inequality, which captures the main and most important points. Then want to talk about 5 narrative violations, which I think are also an important part of thinking critically about inequality, what its causes are, consequences, and what to do about it. And then finally want to talk with a little bit of confusion and uncertainty about inequality and its translation into political power, topic that people are paying a lot of attention to right now. David said that he was also interested in talking about tariffs. I should say my first interview on the day was at 7 a.m. My last interview on the topic ended at 1:45 p.m. And so, David, if you want to hear about tariffs, you're going to have to ask me on the panel. But I'd be happy to answer then. I just may not stop answering. So narrative. I go once a year, the American Enterprise Institute, which is a conservative think tank, holds a conference, and they bring all, Karl Rove, Dick Cheney, all of them show up at this conference, a lot of conservative economists and others, and they believe in diversity, which is why they invite 1 or 2 people with a different perspective than they have. One year they had me on a panel about inequality, and I was sure that the panel would just get bogged down into a debate about whether or not inequality went up or down. And they don't allow slides, so I just brought a handout, made a couple hundred copies, handed it to everyone in the room. And it was a table, and it was about 25 measures of inequality, what their value was in the year 1970, what their value was in the most recent year, and basically almost every one of them went up. That's true of wages, income, wealth, cut those lots of different ways. It's true of life expectancy. It's true of a lot of different environmental or educational variables, true of housing, etc. Almost all of them went up. I apologize, David, I didn't take enough time to update that and put that up on the screen here, but I thought this might be a less hostile audience on that particular question. So economists just don't debate this. Greg Mankiw, who comes more from the conservative side of the spectrum in the economics department at Harvard, wrote an article defending the top 1% a couple of years ago, and he began with, the facts are clear. Inequality has absolutely increased, but here's why, from my moral perspective, I'm not bothered by it. There's a really important set of debates one can have about the causes of the rise of inequality, the consequences of the rise of inequality, what should or shouldn't be done about it, but that gets muddled when you debate whether it's happening at all. So let's just stipulate that it is. Economists sometimes get sort of heated debates about what's causing the rise of inequality. And some of that is like, you're the person who discovered or emphasized factor X, and so you want like X to be the most important thing. As somebody that's a little bit above the fray and reading all of them, I tend to be sympathetic with almost all of the explanations. And broadly, you can group them into 2 broad groups. One, think about the labor market as a competitive labor market. Think about the forces of supply and demand. Demand is affected by the demand for workers with, say, higher educational attainment versus lower educational attainment. So a computer might mean you can do more if you have high educational attainment and replace your job, reducing the demand for labor if you have lower. And then the supply piece matters quite a lot as well. And Claudia Golden and Larry Katz in the economics department here have really emphasized that there was a big increase in educational attainment as the high school movement became universal, as more people went to college through things like the GI Bill, but that all slowed down starting in the 1970s. And as it slowed down, inequality started to go up. So that's the competitive market set of explanations. The other class of explanations are institutional, and they're related to the rules that govern the economy, the rules that govern the labor market, where you set the minimum wage, how easy it is to unionize, whether laws around collusion in wage setting or non-competes are enforced. And those matter too. And those clearly have played a role. The erosion of the minimum wage in real terms, the erosion, the increase in corporate concentration, the reduction in unionization, all of that has clearly played a role as well. And you can look at different parts of inequality and locate different pieces of it there. This ecumenical analysis of what caused the rise of inequality, for me at least, has the implication of leaving no stone unturned in dealing with it. Whether that is longer-term solutions like education, shorter-run solutions like the minimum wage, things that happen after the labor market takes place, like the tax and transfer system. I'm basically in favor of almost all of that, and think each of it has a different piece to play. This is the relatively standard narrative, and everything I just said is true. Everything I just said, I think, is first order important. But I want to turn now to a number of ways in which the narrative is complicated, and I'll list 6 of them. I started out by saying almost every form of inequality has increased in the last 50 years. One form of inequality has decreased quite a lot, but not at all been close to been eliminated, which is the wage gap between men and women. 50 years ago, women made just above 50% as much as what men made. Now women make 83% as much as what men make when they're working full-time and year-round. So there's been a big compression of male-female inequality, and you see that across the income spectrum. Some of that is changes in laws and the enforcement of those laws. That gets to the institutional side. Some of that's very well explained by the competitive model, as women have increased and now surpassed men in terms of educational attainment. Some of that is cultural and institutional changes, including in attitudes and the like. But there's still that 17% gap left. And that's a gap that's really important to understand what does and doesn't cause it. Some people will point out correctly that if you control for everything, industry, occupation, number of years of work experience, that gap basically goes away. And you can debate, is there 5 cents left or 1 cent left or 0 cent left? That's true, and in some ways that's a fact. That tells us something important, but it doesn't tell us, in my view, that there's no issue at all. The important thing it tells us is that by the time you get to the job interview, there's not actually a huge difference. That's not to say there isn't some. I'm sorry, if you have 2 identical people interviewing for the identical job with the identical experience, there's some difference in treatment. There's some additional need for enforcement there. But the bulk of where the differences emerge are things like, why does somebody have a more continuous work experience? Why are there certain industries and occupations that some genders do more of and others do less of? And Claudia Golden, who I mentioned before, has done some of the best research on this, trying to understand, for example, the role that workplace flexibility or childcare or paid leave or how you do tenure clocks, all of these things which are in some sense facially gender neutral. They're not explicitly discriminatory one way or another, but have extremely disparate impacts in terms of everything that gets you to that point of the job interview, the role that they play. And so understanding where this difference does and doesn't come from can help you diagnose what should be done going forward. The second narrative violation is this increase in inequality is definitely more inequality today than 50 years ago, but it's not a process that's gone straight up for everything. For some things, it's leveled off, and inequality's even been declining. One of the amazing success stories that I don't think one should be shy about telling and talking about success in this area is wage inequality has been declining for about a decade now. And the decline is particularly pronounced if you look at the gap between people at the 90th percentile and the 10th percentile. There's been a smaller compression of inequality, but some compression between the 90th percentile and the 50th percentile. Now, trivial narratives like, oh, so-and-so was elected president and it happened, I don't think really help. It started under Obama. It was true for all 4 years of Donald Trump, and it was true for all 4 years of Joe Biden. Some of it we understand, and it's a large increase in the minimum wage at the state level. Basically, states started to give up on the federal government raising the minimum wage again, and a number of states started to raise inequality, and if you look, especially that matters at something like the 10th percentile. Some of it actually isn't well understood because there's been less research on it, because it's a newer phenomenon than the rise of inequality was. But all told, part of why I'm talking about it is, one, it's true, and two, that there's actually some really interesting research that a group of economists did where they gave people more information about inequality and how terrible it is. And the result of this, when they studied the group that got the information and compared them to a control group that didn't get the information, the group that got the information was not any more interested in raising the minimum wage, raising the top tax rate, expanding benefits, doing anything about inequality. That sort of puzzled them because they did actually learn that inequality was worse. They were convinced about it, but they didn't want to solve it. Why? Because for that same group, trust in government went way down. And so all of a sudden they're like, I'm more worried about inequality, but I hate the government even more and I don't trust them to do anything about it. And it paralyzed them. And so this decline in wage inequality for the last decade, I think it's interesting puzzle as to why it's happened. I think it's an exciting positive development in the world. I think one should be able to talk about it without worrying that, oh, this means inequality isn't a problem, we don't need to do anything. Maybe precisely the opposite. Let's learn what helped contribute to the success, like the state increases in the minimum wage, and have more of that, rather than say we solve the problem. So that's the second narrative violation, the non-monotonic, and why I think it's important. The third is that the patterns of this inequality don't exactly match the patterns that you might think. One of the worst forms of inequality, I think, is employment inequality, not wage inequality. People who just don't work at all versus people that do, and the marginalization that not working can give you from society and more broadly. So let's look at that. If you look at black men, their employment rates are much lower than white men overall, and if you control for just about everything you could imagine to control for, there's still quite a large gap. Black women, on the other hand, actually have higher employment rates than the average for the country as a whole. If you look at Hispanic, it's the exact opposite. Hispanic women control for anything you want, have lower employment rates than the population. Hispanic men have higher employment rates than the population. I don't know exactly what explains all of this. If you look at the Hispanic side, culture is certainly a part of it. You look at Catholic countries and employment rates for women are much lower in Catholic countries than they are in other countries. But I'm sure it's not just culture. I'm sure there's a whole bunch of other factors here. But trying to get at some of this complexity is necessary if you want to solve it. Fourth, I said that what was going on in terms of the market was not monotonic. That's the same thing in terms of public policy. What's happened to the tax system over time, whether it's become more progressive or more regressive, is actually quite complicated. There's parts of the system that have become more progressive, expansions in the earned income tax credit, reductions in the tax rate for middle-income people, expansions in the standard deduction. There are parts of it that have become more regressive, reductions in capital gains and dividend rates, reductions in the corporate rate, and depending on how you measure it, you could make an argument that the tax system has become more progressive or less progressive. Benefits, though, are unambiguously more progressive. Medicaid has expanded quite a lot. The Affordable Care Act was not in existence 50 years ago or even 20 years ago. It is today. Supplemental nutritional assistance programs, SNAP, what used to be called food stamps, have expanded over time. The earned income tax credit and refundable child tax credit have been expanded quite a lot over time. I think there's a political lesson here, which is there's an old adage that a program for the poor is a poor program, that it's politically vulnerable, and if it's not universal, it doesn't work. That largely hasn't been true in the United States. Most programs for the poor, the sort of Republican fear is closer to the truth than the Democratic paranoia. The Republican fear is you start one of these programs and it'll just grow and grow and grow. The Democratic paranoia is if it's just for the poor and it doesn't help the middle class, it'll go away. And the Republicans get the facts right, are closer on the facts than the Democrats. I sort of prefer the Democrats' interpretation. I think it's a good thing that they stay and expand, not a bad thing, but just in terms of the political dynamic. So I think that political dynamic is important. Interestingly, there was a big child tax credit expansion in 2021, and surprisingly, it was not that popular and it wasn't able to be extended. One of the problems with it was people thought a bunch of the money went to people who didn't need it. And so if there had been more of an income cap, it would have actually been more attractive, at least to certain senators and in a certain amount of public polling. Now, what I just said is an empirical regularity. It's not always true. And so right now, the House budget resolution included $880 billion of cuts to Medicaid over the next decade, or cuts to the Energy and Commerce Committee, which almost certainly have to be cuts to Medicaid. That would be a 10% cut in Medicaid. That would be impossible to do without reducing the number of people enrolled in Medicaid at the very minimum and probably making the benefit worse. Notably, that $880 billion is about 1/10 the amount of money that would be needed to stabilize the debt relative to the economy over the next decade. So it's actually quite small compared to our fiscal policy, but it's quite large for the lives of the people. And by the way, it isn't being used for debt reduction. It's being used to offset about 1/5 of the cost of the tax cuts that are being considered right now. But we'll see how that $880 billion fares. As many have pointed out, the beneficiaries, the people that will be hurt by those cuts, are actually disproportionately in red states, not in blue states. And a number of Republican members of Congress have actually not wanted to cut those benefits because of the people that get them. The last narrative violation, I think I said I had 6, but I'm just going to do 5, is that not every policy you have is going to have the same impact on every form of inequality. Take wealth inequality, something a lot of people are concerned with, and then take a wonderful set of policies, in my view. You expand Social Security benefits, expand support for health care, expand financing for college, make it easier for people to buy a house. If you did all of that, wealth inequality, at least private wealth inequality, would actually go up, not down. Why is that? Because part of what middle-class families save for is all of those things. And if the government does a better job taking care of them, you'd actually need to save less not more. And that gets to subtle things like if you look at wealth inequality and try to value people's Social Security benefits, you see actually less of an increase in it than if you don't try to value people's Social Security benefits, because the value of those has gone up over time. And so not all good things go together, and not all bad things go together. Sometimes you have to decide what you think is most important rather than just a particular index. The last topic I want to talk about before the panel discussion, which I'm really looking forward to, is the translation of inequality to political power. And here too, I think there's the same framework of the narrative and the narrative violations. The narrative is very much true, that if you have more wealth in the United States, either as an individual or as a company, you have a greater voice through political contributions, through contact with candidates, and greater ability to shape public policy. I certainly have my list of things that I think have gotten highly distorted over the topic. Remember once in the year 2000, Bill Clinton was at a dinner. I was working in the White House then, and they asked, he was at a dinner in like Idaho, I think it was, and the person there asked for some data on the estate tax in Idaho because it was coming up from donors. And I'm like, there are only, don't fact check this, the numbers here. There are only 6 people in Idaho that paid the estate tax last year. And I sent that to the person and they responded, yeah, but all 6 of them are currently at the table, or all 6 of their children are currently at the table with Bill Clinton. And so, that's an issue where, there's no doubt in my mind. On the narrative violations, though, and I think this is very important if you want to do something about it, is it the magnitude of inequality that's what matters, or the way in which we allow inequality to translate to political power? So if Elon Musk, who currently has $400 billion, had $100 billion, that would be a massive reduction in inequality, 3/4 of his wealth gone. He still could have afforded to spend $290 million that he spent on the presidential race, or $25 million on the race in Wisconsin. The person that sits at the fundraiser with the president is the richest person in town, and you make everyone in town, the rich people, half as rich. You're probably just going to change the price of that seat, cut it in half, not change who sits there and the influence that they have. And prior to Elon Musk, a lot of the people that I interacted with in the political system that got sort of more voice because of wealth were often people with merely hundreds of millions of dollars, not billions, let alone hundreds of billions of dollars. In part because it actually is cheaper to get a seat at the table with the president of the United States than with the president of Harvard University. It's quite expensive table to sit at. And so I think we do need to put, raising taxes on the rich, I don't think is going to change very much in terms of the translation to political power. It has to be things more on the campaign finance side. The second narrative violation also gets to corporate concentration, and it's on my mind because I was debating Tim Wu at the business school yesterday. When I was in the White House, some of the most fearsome lobbyists were when we were designing the Consumer Protection Financial Bureau. You may remember that. It's an institution we had up until about 2 weeks ago. And when we were designing it, it went after the banks, the big banks. They were pretty much powerless to change how we were shaping it. The Congress was not interested in hearing from the big banks in the year 2009 and the year 2010. The auto dealers, though, got completely exempted from it. And they lend a lot of the money in our country is lent through auto dealerships. They got themselves completely exempted. That happened not because there was one really powerful big auto dealer, but because there were, and this number is a little bit wrong, but only a little bit, 435 powerful auto dealers, one in each congressional district, and they were all important donors in their own district. And that in some ways gave them more political power than if there was just one and, they could influence the 2 senators in their state and no one else would care about them. You see the same thing with hedge funds, private equity, and venture, which have defended the carried interest loophole, not because there's one big powerful one like JP Morgan or Goldman Sachs, but in part because there's many, which are big, powerful, and rich, but not huge in terms of their market share, or something that you could address through antitrust policy. And I could give other examples. Community banks would be on my list as well. So I would conclude by saying inequality is up. I personally think that's a problem. There's a lot of causes of it and a lot of ways to solve it. It is important to keep trying to study some of the contradictions, narrative violations, ways in which the pattern and timing of that increase in role of government policy hasn't been quite as straightforward as one might think. And by studying that and being open-eyed about it, I think you can actually both politically get solutions that people are more excited about and are more likely to last, as well as solutions that are actually better and help solve the problem. But to conclude, all of that does involve a political system, and it's one where I'm quite concerned about the role of inequality in the political system. But I'm less sure that economic tools that reduce that inequality will lessen that, and think it might be the types of political and structural reforms, many of which are, of course, much, much easier said than done. Thank you very much.
Thank you, Jason. That was terrific. If you might sit here, and if I could ask Arnie and Martha, as they say on The Price is Right, to come on down and sit in these chairs here. Whoever gets the short straw has to sit next to me. Arnie, that looks like you. Listen, I hope you can see why I wanted to start this way, right? It's so important both to get a sense of three things you put on the table, Jason, and I'm going to come back and ask Arnie and Martha to comment a little bit from each of their perspectives on these. One is, what are the facts on the ground? And, we can't give up on the idea that there are facts on the ground, even if, they may be contested and they may be disputed, but partly Jason says they may not actually be as disputed as we think we are if we can actually get people to focus on what they are. But the second, which is equally, if not more important, is what's the narrative around those facts on the ground? And how are they construed? And how are they spun? And how do people argue about that narrative and construct that narrative in a way that oftentimes obscures actually what are the facts on the ground, even if people are willing to admit what those facts on the ground are. And then the third is, how does all of that both inform and is informed by and is reachable or not reachable by our politics, by which is itself a product of what the facts on the ground are, as you say, how many auto dealers and how many congressional districts, and the way in which our political system actually operates on the ground, and then what's the narrative around what our political system can or can't do, and how does that energize or inspire people to either do or not do something around these core issues. And if I've got that at all right, Arnie, it strikes me that you have, for your pretty much entire career, have been living at the intersection point or the cutting edge of all three of those things. And maybe I'm going to come back to education and what you've seen about that, but I want to start where you are now, because I know that in some ways, because I have known you for a very, very long time and your amazing family, where you are now is perhaps what inspired you to be involved in everything that you've done since, which is Arnie's parents and his mother in particular was a fierce community activist in inner city areas in Chicago. We grew up together in Hyde Park, where, again, the Chicago Mafia, John Levy and others are from. But Arnie spent much of his time working, living and actually working and being a part of communities that bordered on Hyde Park that, frankly, most of us didn't spend much time on. And that has really, I think, inspired him, if I might read your biography and your friendship correctly, to do many things, but including what he's doing now, which is going back in those communities, which I think it's fair to say, and I'd be curious on Jason's statistics, are far worse off and far less equal and far more depressed than they were even when we were growing up as kids in Chicago. And trying to shift both the facts on the ground, but also the narrative of how we talk about those communities, in particular in the people in those communities, and maybe most particularly of all the young men who are so often vilified in those communities. And I wonder if you kind of take that as a jumping off point to talk a little bit about what you are doing and how it relates to some of those issues that Jason put on the table for us.
I'll try. So appreciate the opportunity to be here and to see Jason again and hear him. And David's such a huge fan of yours. I'll answer that directly. I just quickly, 2 weeks ago, I'll answer Chicago, but 2 weeks ago I spent a couple of days in Jackson, Mississippi, and I hadn't been there in like 2 years. And Jackson, Mississippi does not have clean running water. Most of us don't have to worry about how we drink and how we bathe. Doesn't exist there. In the 2 years since I've been there, they have basically created an apartheid-like system where the white community has a separate police force in the city and a separate set of judges who are appointed, not elected. And so I would argue that inequality is actually the goal. It's not a problem, it's not it's actually the design. It's not a flaw in the system, it is the system. And as we see what's happening nationally, for me, it's just a sense of where we may be going as a country, and was stunning to see. On Chicago, I spend all my time on the south and west sides now, and I live in these different worlds. I was on 133rd and Eggleston last night trying to resolve a conflict where one group had a guy killed 4 days ago and trying to stop the retaliation. Now I'm at Harvard today. It's an interesting life. As David said, our group is called CRED, a couple plays a name, but it stands for Creating Real Economic Destiny. And what I say all the time is I think I'm trying to solve an economic problem, not a crime problem. The violence that we're obsessed with and working on every single day is the last manifestation of every other social ill: lack of opportunity, lack of housing, lack of jobs, redlining, discrimination. And at the end result of all of that, you get untenable violence. And when we grew up in Hyde Park, Lincoln Park, other parts of Chicago, you don't have that. And so the only way to reduce the violence long term is not locking folks up, is not just that we do it, trying to give people a path out of that violence and help them rebuild their lives and become productive citizens and do other things. You really have to have an intentionality behind creating economic opportunity. And just two quick, and Jason does all the stats, he's the economist, I'm not, but two things that really sort of strike me. The St. Louis Fed so I'm always gonna be the education guy, we'll talk about how important that is, but between 1992 and 2016, 24 years, college-educated whites saw their wealth grow by 96%, and college-educated blacks saw their wealth decline by 10%. So education is important, and I'm never gonna say it's not important, but it is insufficient to solving this problem. And in Chicago, 20 years ago, of the top 150 privately held companies, there were 3 that were black-owned. Today, there's 0. So we've gone backwards. And not to be personal with David, but going back, I haven't heard it from him, I've heard it from the other side, but his father and my mentor, my best friend, John Rogers, David's father and John Rogers' mother started their own law firm, LaFontant and Wilkins. I've heard from John because his mother could not get a job in a white firm, and that they had to go do that. And so I would argue that for me, the inequality is a racial inequality, and it's great the gender inequality has closed, but until we are intentional about creating black-owned businesses, and black-owned businesses that can hire other African Americans, and Latino-owned businesses that can hire other Latinos, until we do that at scale, we're going to continue to have these massive inequalities. And then last thing I'll say, John Rogers, who's my mentor and best friend, he talks all the time about business diversity, not supplier diversity. When we talk about supplier diversity, that's the people who pick up the garbage and do the gardening and cook the food, and that's important, but that's not where wealth is created. Wealth is created is who are your bankers, who are your accountants, who are your IT folks, who's doing your legal counsel. And until we think about supplier diversity and creating opportunities in the minority community, we're going to continue to have these untenable gaps and inequality that create the violence that I'm trying to stop every day.
So Martha, this is a perfect segue to ask you for a couple of reasons. You started out your career, and we almost lost you to the field of education, actually, where that was where you thought when you were coming out of school that that's where you were going to spend your career, and have been working very much at the intersection of education, opportunity, and law, but also around issues of diversity, which we can still say in this room, and social and economic justice. And you wrote this brilliant book many years ago, I think it was 17 books ago, last count I had, called In Brown's Wake, in which you tried to talk about what happened since that moment where Thurgood Marshall, our old boss, who we both worked for, thought was going to be the beginning of eliminating the kinds of issues that underlie the sorts of disparities that Arnie has spoken about. And you studied that not just here in the United States, but around the world. And I wonder if, kind of using that as a jumping off point, where are we in Brown's wake? And how can we begin to move towards the ideals that I think people felt very optimistic we were moving towards on May 17th, 1954?
Well, thanks. It's an honor to be here, and I'm already learning a lot. I was especially struck by Arnie's description of Mississippi, because I can say that that's, in a nutshell, what's happening in education. And it's the creation, quite deliberately, of two systems. Some places they're all public, many places they're not. But it's very racial. It's, of course, reflects income, but it's even more about building walls, physically or metaphorically. And, in many parts of the country right now, the fastest growing movements in education are parental savings funds that allows people to buy out from the public system, and the divestment from the vision, not just of Brown v. Board, but we go back to the 1840s, the vision of the common school. That's a common experience. That's not the vision anymore. Education is a commodity, and people want a return on their investment, and they want it to actually maintain, if not increase, status. So that's incredibly depressing, to say the least. I do think that there are, individual stories of educational success, whether it's racial integration or economic integration. It's the scaling up to systems. Arnie is the expert on this. That's been so hard, but I think it's for the reasons that actually we heard from Jason. It's about the political economy. It's about who has access to political power. It is not simply campaign finance. It's also people using the political system to increase their economic welfare and their benefits, and to push other people down. That's what I see. And while I still have great hopes for education, it certainly is an important critical ingredient, especially in a world of a symbolic economy, where most people increasingly will make their lives and make their living using ideas, not using brawn. Nonetheless, unless we tackle the system itself, Jason's remarks, what most stood out to me was that story you told about distrust. I think the distrust in our public institutions is the the biggest problem to worry about, because if we can't come together collectively to tackle our problems, we're not even talking about environmental problems or who's going to be able to afford water as the crisis emerges around the whole world, we will not be able to deal with any of the issues that we're talking about here. And the distrust includes distrust of the law and distrust of the legal system. And there are reasons for it. Some of it are examples of bought judges. A Supreme Court that actually has said, bribes, that's not a problem, is contributing to it, and maybe because some of them may be participating in something like that. A Supreme Court that is not willing to have an ethics code, for example. But I think the loss of trust has got to be the death knell of the American dream. And I don't understand why there aren't more people in the business community who are absolutely on the ramparts about this. When it comes to access to justice, the business community has been absolutely clear. We need to have reliable faith in the rule of law, transparent, sense of trust. But right now, the policies that are eroding that trust are profound.
Well, Martha, as you know, that's an issue that I'm spending a lot of time trying to think about, and I think is absolutely critical. But I want to come back to you, Arnie, to talk about really the narrative around these issues, because it seems to me that the problem is that we've lost control completely of the narrative around what government can or can't do, what it's for, what its purposes are. And again, the work that you're doing now is in a community where not only is the external narrative one of distrust, but the internal narrative of everyone who's living in that system is also one of distrust. And how do you, in the work that you're doing, and as it connects to the past work that you did around the value of education, convince the people who need it the most that it's actually a way out as opposed to just a further trap for where they are?
So on the narrative question, this is the hardest work I've ever done. It's the most heartbreaking. It's also the most inspiring and hopefully over time the most meaningful. But I learned so many hard lessons every day. But last night is, trying to mediate this conflict. One of my team is a guy who had a life sentence without parole that President Obama pardoned. I didn't know him. He came out. He's now one of my senior guys. The other two guys that served time in penitentiary and came out. But just the redemptive power of the human spirit with opportunity and learning not to judge. And these are guys that at one time were absolutely terrorizing the community, and now they are literally the greatest warriors for peace. And so just witnessing that every day, that's the joy of my job, and seeing that power and knowing what's possible. And that the overwhelming majority of folks are caught in these cycles of violence, not because that's what they choose, because they did not have a choice. And we're just giving another option. And the vast majority are choosing to do it. And progress isn't linear. We have good days, we have horrible days, but just seeing what's possible. And Brian Stevenson's one of my heroes, and just being proximate and just witnessing that every single day, it's the most incredible thing I've ever been a part of. So trying to tell those stories. I almost never traveled by myself. When I did this, I normally just bring my guys with me, and we talked about and have them tell their stories, and for you guys to understand what extraordinary leaders they are coming from that. On education specifically, it's really interesting. It's not a hard sell for us. We get all of our guys their high school diplomas. It's one of our biggest celebratory days each year. Our oldest graduate was a 62-year-old security guard, and she danced across the stage when she got it. But guys walking across the stage with their kids, and some of our guys literally never went to high school. They never made it to high school. So it is not a hard sell. It's not that they don't think it's an opportunity. That door was closed to them for whatever reasons in their life, that schools weren't safe for them, or they had other responsibilities, or they got locked up, whatever it might be. But we have a cohort of our guys now in college together, and that's a pathway that folks desperately want. It's just they haven't had the opportunity. So it's not a sales job. It is a creating concrete opportunity and walking with people to take advantage of that.
Martha, I'll come back to you, and then Jason, I'd really love, as you sit and listen to this, how you think as an economist and a policymaker we ought to think about this. But Martha, I know that you are you've always spent all your time on this, but you're now spending your time thinking about it in writing something both analytic, both true and persuasive, which are these things we should both understand them as important goals, around how do we construct a new politics, a new narrative for our politics at a time in which we live in such a fractured world, in which you say the schools aren't common, but neither is the nightly news and neither is the internet. And like Justice Liu, I'm actually not on social media. I can't figure it out, but nothing in there is common. It's hard to know what is common, maybe the Super Bowl or something like that, or some sporting event. But other than that, how do we begin to resurrect some sense or understanding of the common good that doesn't paper over difference or submerge, everybody to one dominant narrative that frankly doesn't apply? I mean, this is Jason's idea of multiple perspectives and multiple narratives. How are you beginning to think about that?
Well, you're going to help me. I'm counting on that. I think the only hope that I see is local, working bottom up. People who know each other are less likely to demonize each other. People who have to actually deal with the local garbage. It's less politicized than a lot of other issues. It's one reason that I've spent a lot of time on the decline of local news. The loss of the news industry in local communities is not just hard because then you don't know exactly what's going on. It's the loss of the virtual community that you have in common, that we're sharing this experience. So, philanthropy is coming to the table. There are a lot of people now working on trying to revive local news. I do see stories that are very moving at a local level. One of my students has been working with a juvenile court judge in North Carolina who says the people before me, they're symptom, they're not the cause of the problem. And how can we create a different set of opportunities for these people? That's in North Carolina. That's pretty hard. But there are stories all over this country of people who are just diving in to make things better. And often because they can know each other. They can actually find some point of commonality. It's not that they're necessarily all buddy-buddies. So, I'm a big fan of federalism. It's a moment where it's actually maybe the only place that we're going to make things work. But on a darker side, if we're living in a society in which it is illegal to talk about the nature of our problems, you can't name them. There's a list of banned words that if you use them, you will be cut off of public support. They include race, marginalized, diversity, gender, women, socioeconomic. I mean, there couldn't be anything more overt than the fear of naming what is going on. So I feel very strongly that the politicization of our words is the deeper problem.
Please, Arnie.
I couldn't agree more that it's got to be local and proximate and people knowing each other. I'll give a counterexample. I'm always hopeful of where could we come together, not with the current administration. This is an anomaly. This is unprecedented in our nation's history. But I do think education should be the ultimate bipartisan or nonpartisan issue. And I would like to think if we set a couple what I would call nation-building goals, more access to pre-K, third grade reading scores, raising high school graduation rates, more folks going on to college and graduating. Those aren't left or right or R&D goals. If pushing the current administration to the side if the rest of us could come together behind those goals, measure progress, be accountable, look at what states are doing well, what districts are doing well, how do we learn from each other. That might be a way to try and knit folks back together.
So Jason, that's a great entree to come to you, and I'm going to give notice to the audience that we will reserve some time for your questions. So if you have questions, be thinking about them, and I think we have microphones someplace around here for people who want to ask questions. But Jason, as a research economist at your core, you're a policymaker, you're a public servant, but one of the things that made your presentation so compelling was it had all this data behind it. And yet we now live in a world in which I wonder how you're going to think about collecting that data and trying to get at where there actually has been progress and where government has been working in a world in which even asking the question, let alone collecting the data about it, let alone naming the results of it, has become increasingly difficult and has become increasingly polarized in a world, to quote someone who's at least not in this version of the administration, alternative facts rules. So how do you think about that?
Yeah, so first of all, I'm jealous of Arnie's ability to sort of depict things in a really, really vivid and tangible and important way. I mostly sort of look at numbers and I can tell you if they're going up or going down or staying the same. I think it's best when those two things match up, which they did in that case. And you can do numbers pretty well, Arnie, much better than I can do images. But having them match up is really important. I was listening to you, Arnie, and saying, yeah, of course everyone should want that. But they just ended a bunch of these data sets and exactly what you would need to track the goals that all of us should have. I think sometimes that's, to Martha's point, because they don't like what the data will show and you'd rather the data disappear. I think sometimes, though, and probably more of it, is just utter sort of carelessness, disregard, and not just caring at all, as opposed to some grand master plan of like, let's get rid of these 3 data sets because these are the 3 particular ones that give the results we don't like. It felt less like that. I certainly agree, at the local level, there's this recent book that's gotten a lot of attention and debate by Ezra Klein and Derek Thompson called Abundance. One of the things that I think is really important about that book, and just to be clear, I think it is a useful tool that we have. It is not everything, but it's a useful tool. One of the useful things about their emphasis on building more and increasing supply and reducing red tape is that's something you can do here in Cambridge. Are we in Somerville or Cambridge? Okay, we're still in Cambridge. Okay, great. They can do it in Somerville, right across the street, as well. That's something you can do in Massachusetts, and so you don't need a federal lever. Policies that I obsess over, like the earned income tax credit, that mostly is a national policy. Some states can pull them off. It's pretty hard for a city to pull something like that off. So having a sort of diversified set of things you're pushing at so that when you're not making progress at one level, you can make progress at another was a point Martha made that I very much related to.
Well, I think we need all levers pushed. So let me open up the floor. We have actually, as I hope all of you know, a very informed audience of people who are often working in these issues or deeply care about them. My colleague Dana Walters here has a microphone, and please let yourself be recognized. Yes, please, right here. Thank you. Oh, sorry, then we'll come down here. Yeah, okay, I'll sort of try to keep the cue. Go ahead.
So I'm David Udell, the National Center for Access to Justice at Fordham Law School, and I have to step out for a second. So if you already spoke about this, please let me know. But one thing I wanted to observe is that most people hate the concept of the rule of law because they think it's like the traffic law or the criminal law, or it's all the law that's coming after them all the time. And I think many of us in the access to justice community try to build the argument that without access to justice, the rule of law can be oppressive. And I just wonder if you could speak more to the messaging around those concepts and how we can pull people into supporting the rule of law on the theory that it's sometimes some things that they should hate. So.
Martha, you want to take a crack at that?
Well, you've done more than just about anybody to work on that, but I do think that the phrase rule of law is not resonant with just about anybody but a lawyer. But what to unpack it, and as you do and some others are trying to do, to show that it's about fairness, it's about transparency, it's about being able to have clear rules that are fairly enforced and across the board, and hold accountable those with power. If that's a definition, I think it would get much more support.
And I'll just say, Martha already alluded to this, but my colleague John Coates and I are working on trying to get people to understand that it's also critical for American competitiveness. I mean, quite frankly, if the goals of the Trump administration are to make America, prosper, I'm not going to say the phrase, but make America prosper, to bring jobs back, that's going to require people, often foreign investors, who believe that this is a safe place to put their money. And if they get into a dispute with the government, that they'll be able to hire the best lawyers and have neutral courts. And I think the reason why America is the reserve currency and the premier source of foreign investment, and the reason why China and Hong Kong are fading and Singapore is booming, is exactly because of these attributes of the rule of law. But yeah, Deborah Ramirez.
Hi. First of all, I want to thank you, David, and the Center on the Legal Profession for bringing us together today. I don't know why different people come, but I came because I'm really frustrated at what I'm seeing, and it involves access to justice, the rule of law, and inequality, and worried about, okay, what can we as individuals do? So first, I want everyone to know that this Saturday at 11, there is a national protest day for people who want to protect the rule of law, who are advocates of access to justice, and who are worried about inequality. So that will be nationwide. In Boston, it will be at the Boston Common at 11 o'clock. Second, one way that I think might be useful is what my friend Sydney Hanlon is doing. She goes to eastern Pennsylvania, where her family was from, and talks to people who are Trump supporters. And she talks to them about the rule of law, about access to justice, and about a lot of other things. Because if all the news comes from Fox and there is no dialogue, it's hard to find commonality. And finally, in terms of acting local, I live in Lexington, and I went to a local event on public affairs. I was shocked by the questions they asked me. What is a TRO? Should unelected judges be telling the president what to do? Do people who have green cards and student visas have the same constitutional rights as we do? I was surprised at the fact that some people don't really understand. And so I spent some time explaining in a very nice way. And at the end they said, I hope you'll come back. And this is Lexington, Massachusetts. So I think that engaging in dialogue might be useful.
Arnie, maybe if you could talk as someone who has put your individual self, but also mobilizing individuals around what they can do, because I do think what Deborah says is felt by many people. What can I do? I feel helpless.
Well, this is rarefied air. I think across the country, the average American spends 4 minutes a day thinking about politics. This room probably thinks about a lot more. Most people are trying to put food on the table and pay the rent and pay the light bill and make sure they got child care. And I do think those conversations now, there is a moment. Are the price of eggs down? Are your retirement savings up? Are your job prospects up? What's happening? There's a moment now that if we lose it, I frankly worry we lose the country. I'm going to Florida Saturday to engage in conversations in the heart of what's known as Moms for Liberty territory, to talk to folks, and other folks are going into other places. And so I think we have a crucial moment to try and talk and listen more, maybe listen more than talk, and see if some folks who believe some things or were desperate, if those things aren't happening, is there a chance now, a moment to move them or not? And so I think it's a desperately important moment, honestly, in our country's history right now.
Yes.
Good afternoon. I'm Colleen Cotter from the Legal Aid Society of Cleveland. Thanks for inviting me here today. I'm really intrigued by this intersection of economic theory and access to justice, and the thing that's been going through my head is, from my perspective, sort of on the ground of trying to increase access to justice very locally in Cleveland. It feels like a lot of the inequality comes from a scarcity mindset of you have, therefore I don't. And instead of a both and, it's an either or. And I wonder if in thinking about equality, inequality, access to justice, what we can learn from economic theory on scarcity mindset and how it actually works in economics.
I assume,
Yeah,
Jason, that's for you.
I mean, I'll bet lots of people have choices, but yeah, I think that's a super important point, which is, one of my colleagues, Stephanie Stancheva, who actually co-authored the paper on the decline in trust when you told people more about inequality, has been doing research on zero-sum mentality. And it's very much related to the mentality that says you don't want immigrants, and you don't want trade, and you don't want to make investments in people because this person takes advantage of it, and it hurts that other person. And tracing sort of why that zero-sum mentality has risen, and what I think a lot of the harmful consequences of it are. And to be clear, there's sort of a right-wing version of it, which is the one we see in the White House right now. There's also like a left-wing version of it, that the only way to make anyone better off is to make someone worse off. And that's often not the case. I personally think Jeff Bezos got most of those billions of dollars by doing things that benefited a lot of people. I also think he could afford to pay a lot more in taxes than he does too. But I don't sort of begrudge the business he built, but I do begrudge the tax rate we've chosen to have for him. So I think that zero sum, there's a lot of research that gets at exactly that intuition. And again, that book Abundance by Ezra Klein and Derek Thompson I talked about, part of it was a plea for people, more on the left side of the spectrum to have a mentality that's positive sum rather than a scarcity mindset, which they saw as getting in the way of a lot of progress that progressives would like to make.
And that scarcity mindset is based on a very old view of economics. I mean, that actually most economic professors don't believe in, right? So, I mean, trying to understand the growing the pie idea was always at the core of what we thought, and yet we've totally got away from it. I agree. We have time for a couple more questions, please. Thank you.
Thanks. I'm Carol Bergman. I'm with the Legal Services Corporation in Washington, and I head up our government relations work. So I'm on Capitol Hill every day, certainly this past couple months. And I want to go back to the local issue and add something to it. I cannot tell you how important it is for people to talk to their members of Congress about how they feel about what is going on. They are so scared. You can all see it. Nobody has a spine. Nobody's able to speak up to, this administration. They're all scared about being primaried. And the only thing that matters other than Trump is what they hear from their constituents. It's critical. They all have to be reelected. That's why they care about being primaried, but they care about what their constituents are saying and what matters to them. So when you're having those conversations, if you're talking to folks, especially in Republican congressional districts, the most important thing people can do is reach out to that member and make their voices heard.
Thank you. Yes, right over here. Thanks. Dana?
I'm Gene Fidel. My field is military law. I want to make an observation, and I've learned a lot from your comments. I want to talk about the legal profession. The building is on fire. the people who can help control the fire, contain the fire. We have a house in Pasadena. Fire's been on my mind. The people who can help contain the fire are members of my profession. And I have two comments I want to make in this respect. Good news and bad news. The good news is that members of the profession have in fact stepped forward. Not everybody, but some have. And blessings upon every attorney and every law firm that is standing up. Without them, the fire would be raging even worse than it is. My second observation concerns legal education. My side hustle is I teach law, and I went to a nearby law school. I thought when I was at the nearby law school that one of the things we were learning, aside from the rule against perpetuities, was something about leadership and something about personal responsibility. And I have been appalled at the kinds of crazy, valueless behavior that even graduates of the leading schools and the other schools around the country have been displaying. People whose values and orientation shift with the political winds, or don't. People who, interestingly, come to law school with fixed views rather than gaining anything from their legal education. So not to fault law schools, except when I look at the products and I see one, quote, leader after another displaying what can only be called bad behavior, politically speaking. And I don't want to sort of divert the conversation here, but I would hope that people who work in my part of the forest will be thinking about those issues.
I'll just say it's not a diversion at all. And we can take one more question down here. It's not a diversion at all. And I think that it raises, I think, a fundamental question about what is the purpose of legal education and what are we training people for? And I think that has never been more crucial to answer, but also more in doubt than it is today. And I'm not just talking about the events you're talking about, although those are critical, but your comments really suggest not just about the current political moment, but about what we are training people for more generally. And I think partly what I tried to get at a little bit in my opening remarks was that lawyers have to think about themselves in a different way. That is, it was a very kind of technical discipline in many ways. There was always a kind of hopeful public ideal behind it, but it was often taught in a very technical way. That's your point about the rule against perpetuities. Sorry for anybody who's not a lawyer here. Yeah, not that we have anything against it. But the fact of the matter is that law today, if it is to be meaningful, has to be thought of as problem solvers who think about integrating a wide variety of knowledge around legal issues, but also much broader than law, to think about and grapple with the most important issues in our world today from a perspective of a deep perspective of values. And that isn't the way in which law has traditionally been thought of or taught, and yet it's more important today. So I hope you will be engaged in whatever law school around the street or around the corner that you are in, because it's hearing from alumni and from people who, judges and others we have in this room, that will help us to move the needle at a time of real crisis. So one last question, please. Thank you.
Hello, my name is Geras. I work in legal technology as a researcher, but I wanted to ask a question more, just maybe a comment about the precedent of top-tier U.S. law firms, making an agreement with the executive of a country to, in terms of a billable hour contribution and settlement for their involvement in prior prosecution of the now sitting president. So it'd be interesting, and some other law firms deciding to fight in a court of justice.
Yeah.
Well, David has been really the expert on this, but I guess I think it's very striking to see that the law firms that are capitulating are more dependent on the business income as opposed to the lawyers who are litigators, and more dependent on a few rainmakers who threaten to leave, with the rest of the profession circling around like vultures to pick them off. Whereas those that are standing up, I'm sure that there's principle involved, but there's also a little more economic viability. And there's a vulnerability that I hadn't really understood of law firms to quickly falling apart that has something to do with the ownership structure, the lack of diversification. And I've been thinking more in the last month than I have in my life about the claim by the founders of the United States, some of whom created this organization, that independence is necessary for political freedom. And the dependence of these lawyers, universities, groups after groups after groups, or the perceived dependence on the government, on a few wealthy clients, I think has warped any competing source of value. That's the tragedy of this moment.
Two quick thoughts, and these guys are legal experts. I'm not. This may be naive. I think for those firms that are capitulating, what I think needs to happen is you need to protest their clients, their other clients, and put a counter pressure. They're under immense pressure to capitulate. There's got to be a different counter pressure that makes it hard for them to capitulate. And we're missing that. And the same pressure on law firms, on universities, and Harvard's now at the bullseye. Personal opinion, universities can't fight this by themselves. They have to come together. They'll just get picked off one by one individually. And when you're dealing with a bully, you give him your lunch money one day, he comes back the next day and the next day and the next day and takes all your lunch money. And this is not an assault on higher education, it's an assault on democracy. That's what's happening here. So until universities decide to stand up 1,000 presidents together, 5,000 presidents together, say we're not going to compromise our values. If we don't see that, we will see our system of higher education disintegrate before our very eyes.
And that's true for the legal profession as well. And I think that's both a question of organization and of convening, which is one thing that law schools ought to be and hopefully can do. But I do think this, and it's very easy, and this often happens, to not just pick off one institution at a time, but then to pile on the institution that gives in under pressure as if that's the main problem. The main problem is the people putting the pressure and the illegitimate demands that are being put on institutions which are vulnerable for all kinds of reasons. And then to figure out how to rebuild an infrastructure around the professions, around the universities, around the institutions of democracy that are more resilient. We have found out that we have allowed our institutions of all kind to be hollowed out. Listen, this is an important discussion. I promise we will continue it both in the next panel and for a long time to come, but we have promised to keep on schedule. One thing we pride ourselves on, we start on time, we end on time, and we have promised you a coffee break where I hope the discussion will be continuing. Please come back. We're maybe a few minutes behind schedule, but if you could come back right at 4:15 sharp, and we will continue this discussion. But please thank my incredible panelists, and Jason in particular, for being here. Thank you. So could we have everybody come back, take a seat? Again, one of the things about these kinds of meetings is it's wonderful, all the conversations and everybody wants to talk, but it's also important for us to have a common conversation. Actually, Martha has always talked to us about the importance of common conversations and common institutions. Listen, we want to transition, but build upon, I think, the incredible insights and energy of the first panel by now focusing more directly on what Verna and I, when we first started thinking about this, brought us together, which is the yawning and increasing access to justice problem. In many ways, if there's at least glimmers of good news that David said about inequality in general, I hope we'll be able to find them around access to justice, although mostly what we see are really the just increasing challenges. We have a terrific group of speakers. Again, the format will be the same. David Engstrom from Stanford Law School, who's already been talked about because his work has been so extraordinary in this area, is going to kind of start us off with some opening framing remarks. And then we have an absolutely terrific panel comprised of Dan Yee, who says in your program is a fellow at the Center on the Legal Profession, which we're honored about, but he's been doing so much more before then, creating the idea of innovation in the Justice Department, helping to run the Access to Justice arm of the Justice Department, as well as being a special assistant to the Chief of Staff to the Deputy Attorney General. Verna Williams, who's already been mentioned, whose distinctions go very far beyond and in spite of her being my former student, and that she's now the CEO of Equal Justice Works. Kelly Testy, who's now at AALS, but was at LSE before then, and has really been a leader in thinking about access and opportunity in the legal sphere. And then Ben Jackson, who's the co-founder of Upsolve, which is one of the most important, innovative new startups, although I guess you're far beyond being a startup today in this area. So let me turn it over, and please open us with some remarks. Thank you, David.
Thank you, David. All right, so thank you, David, for that very lovely introduction, and thanks for the invitation to be here today, and maybe particularly for the opportunity to offer some framing remarks right here at the outset in advance of this really terrific panel that we're going to hear from in just a moment. So let's start with the problem. The best evidence is that in something like 75% of the 20 million civil cases filed in American courts each year, at least one side lacks a lawyer. And if you look under the hood, these cases, they might be small scale, but they're actually high stakes for the people concerned. They are overwhelmingly debt collections, evictions, home foreclosures, and then certain types of family law. Dig a little deeper, and we can say a couple of further really important things about these cases. First, most of them pit an institutional plaintiff, so a bank, a credit card company, a debt buyer, maybe a corporate landlord, maybe the government, always with a lawyer, against an individual defendant without a lawyer. Second, many or most of these cases end in a default judgment when the defendant fails to show up. at which point the plaintiff can, whether there were legal defects in the case or not, seize money in a bank account, get a wage garnishment from an employer, or evict the person from their home. How did we get here? How did we get to the point where the modal case in the entire American legal system is a debt collection action? One side with a lawyer, one side without. There are a bunch of theories. I don't have time for a full tour, but I can take you on a quick one. Some of it is surely declining or at least stagnant legal aid funding. Also, while poverty rates have been fairly stable in recent decades, precarity hasn't. According to Yale's Jacob Hacker, Americans now have a 17% chance of seeing their family income drop by more than half from one year to the next, more than double the probability in the 1970s. Third is what I like to call technology's affordances and asymmetries. You know, those institutional plaintiffs I mentioned have increasingly deployed technology from some pretty basic robotic process automation to AI to assembly line cases through the courts. That's how some plaintiffs manage to file 10,000 cases in a year in many jurisdictions. That's technology's affordances. In the meantime, and for a mix of political and economic reasons that I'll explain in a moment, individual defendants haven't had the same access to technology's efficiencies. That's the asymmetries part of affordances and asymmetries. Finally, and perhaps most important of all, the civil justice system is really hard to navigate. It is a maze for the average American. After all, it's a system that was built by lawyers and for lawyers. All right, so what do we do about this? The conventional view is at least three things. We should increase the supply of legal help. We should make the system more navigable by those without legal help. And we should try to build scalable, and that often means technology-based, ways to improve or even remake the system. Now, I could roll through each of these in turn, but I've come to believe that maybe they're not all created equal. And so I want to explain, maybe as a kind of provocation for the panel that we'll hear from in a moment, where at least, I'm putting my chips in terms of the time and resources of my team out at Stanford. So start with increasing the supply of legal help. And I'm sure that Kelly and Verna will have views on how we can build a better pipeline of talent within the profession. I think you'll hear about that in a moment. The main place I've worked on this issue is regulatory reform. That is the uninspiring label that only lawyers and law professors could come up with for a political movement to describe growing efforts around the country to relax the usual rules that say that only lawyers can practice law and only lawyers can own and therefore capitalize law firms. The goal of this is to make more room for human non-lawyers. So think of like a nurse practitioner type person for law, but also non-human non-lawyers or software. So my team over time has advised a bunch of different state Supreme Courts on how to responsibly relax these rules, and we've done some empirical work as well on the types of legal innovation that resulted in the two states that so far have in a really full way relaxed those rules. That's Utah and Arizona. And we actually have a follow-up report with more data coming out next week. And the results in those two states have actually been quite promising. Outside Utah and Arizona, though, it's really 2 steps forward, 1 step back. A few years ago, I was part of a blue ribbon group in California tasked with making a recommendation to the state bar and the California legislature and the California Supreme Court about how to responsibly relax those rules. And after a year and a half of work, we were unceremoniously shut down by the legislature, in large part because of opposition from the plaintiffs' bar and, interestingly, from legal aid groups. So I wrote an intemperate piece in Slate expressing my displeasure with my supposedly progressive home state. So, even so, regulatory reform has become something of a movement with quite a bit of activity and a few successes. Those are the dark circles that you see in any particular state. But it's also a slow-moving movement. And the reforms that are able to make it through that political gauntlet that I think I experienced in California may not always be fully scalable. I think a good example here, and I know it's controversial, but is the growing traction of community justice workers, in which legal aid groups and certain community organizations are given the authority to hire, train, and supervise non-lawyer service providers. These are amazing programs, and we need more of them. But at least some of the models really rely on a bricks and mortar base of legal aid. They extend legal aid's reach, but they can only reach so far. All right, what about a more navigable system, if that's what we wanted to think about, and we'll probably hear from the panel about this a bit as well. What would that look like? There have been tremendous efforts in the past couple of decades. We've built all sorts of new self-help tools for self-represented litigants. Courts have adopted forms that help self-represented litigants file pleadings and papers. We've got court navigators to help litigants find their way around the system. I'm proud to be doing some work here too, including by leading the American Law Institute's project on high-volume civil adjudication. And so far, we've started in by proposing some revisions to large swaths of civil procedure, from notice to pleading to entry of judgment, to make it easier for self-represented litigants to navigate the system or to be served by low-cost legal services providers. This will all surely help, I think, but it too has its limits against such an enormous, enormous problem. In some ways, reforming procedures is, as my charming Southern wife would say, lipstick on a pig. Procedures alone simply aren't going to be a complete solution on a badly slanted litigation playing field. All right, last piece of this, like scalable solutions. That's the final reform thrust. And here's where, my, or at least Stanford's chips currently sit. And of course, when we say scalable, that by and large means technology. And, here I have a view, until that is maybe Ben Jackson, really sets me straight. But anyway, here's my way of thinking. One way of incorporating technology, especially AI, into the civil justice system is to make it easier for a growing cast of legal tech companies out in the world to serve people. And so we should, in other words, be doing everything we can to foster a robust legal tech ecosystem. After all, legal tech is a booming field, especially, by the way, when it comes to serving corporate entities. But we're also starting to see legal tech companies that serve individuals. And so Upsolve is just a really great example of some of the remarkable innovation we're seeing. I worry about this, though. I increasingly wonder if it might be a false hope. Reg reform, I already noted, is not moving so fast. And as a result, the Upsolves of the world remain pretty limited in the types of services that they can provide. More importantly, there are other barriers to a robust legal tech ecosystem. If you look out across the roughly 16,000 local court jurisdictions that make up the American legal system, you see a checkerboard of technology systems and data infrastructures. And that's really important because it makes it really hard for legal tech companies to get the scale that they need to build sustainable business models, serving people who almost by definition have limited ability to pay. And unlike, say, a TurboTax customer, might only need services once. The market economics here are just really challenging. The other way to incorporate technology, and especially AI, into the civil justice system, and here finally is where most of my chips are at the moment, is the courts themselves. And so last year, my Stanford team and also Margaret Hagan's legal design lab out at Stanford announced a big collaboration with the LA Superior Court. That's the nation's largest trial court. The court adjudicates more cases in a year than the entire federal court system combined. And with amazing access to their systems and data, we've asked some hard questions about what's working and what isn't, and we've built a blueprint for starting to think about what could be done in the eviction space. Now we're turning from diagnosis to action. And as we do, I think some of the most important work that we're doing is what I call courthouse AI. That is to say, working with the court to help it design, implement, and test new AI applications. Some of the applications that we're building you can think of as litigant-facing, right? They serve litigants in a direct-to-consumer sort of way. And eventually, of course, the court wants to work its way up to the point where a court user could come to the court's website, enter a plain language description of a civil legal problem, and get back actionable information, and also get connected to tools that they might need to perform a task of some sort. That, by the way, is the incredible promise of generative AI, and I suspect Ben will talk a little bit about that during the panel. So an initial foray in all of this is we are starting to help them build that vision, and we are developing what we're calling a triage referral tool. That's a tool where the litigant could come to the court's website, enter some information about their case and also their preferences, and get back a curated set of appropriate legal help options. That's one thing we're doing. The other tools we're developing, though, are internal court-facing ones. And in some ways, I'm actually more excited about these. Many cases in high-volume dockets, we already noted, end in default judgments because the defendant fails to show up. And so some courts have started to do what are called default prove-ups to ensure that default judgment is legally warranted, even though the defendant isn't there to contest it. For a few years now, the LA Superior Court has been doing prove-ups in a purely analog, human, eyes-on way. A single court staff member, call him Kevin, does them to the tune of thousands of cases per year, and it takes him roughly 20 minutes per case. But Kevin, it turns out, is about to retire. And so one of the projects we're working on is automating parts of the prove-up process by building an AI-based prove-up assistant. Done well, our prove-up assistant can be transformative in a system in which the adversarial process has mostly broken down. The rejection rate in the current prove-up process, that human analog eyes-on version of it, is about 1%. And based on our initial data work, we think that the rejection rate might actually be 10% and maybe even higher with a proper and well-designed AI prove-up assistant. That's a many orders of magnitude improvement in accuracy. Maybe best of all, our work can be exported to other courts that could never afford a Kevin in the first place. To be sure, plenty of challenges here. Courts lack significant technical capacity of their own. There are only so many Stanford research teams out there willing and able to do the work. But still, I find courts to be the most promising way to bring AI into the civil justice system in an effective and trustworthy way. And I think that courthouse AI is one of the most compelling but also underappreciated and underdeveloped parts of a growing public interest technology movement. All right, let me close with a charge to everyone in the room. I think a lot of the conversation so far today has linked access to justice to poverty alleviation and inequality. Not entirely, but a lot of our conversation was based on that. And that's really important, and I definitely don't want to minimize it. But I think access to justice is important for another, and maybe given our current politics, maybe even more pressing reason. Expanding access to justice, opening courthouse doors wider for all is needed to bolster the legitimacy of our courts, and by extension, to bolster the rule of law. Back in the 1990s, political scientists talked a lot about democracy at the DMV. The DMV was, for many people, their most frequent touch point with their government. And it wasn't going well, with all kinds of implications for faith in and support for government. But fast forward 30 years, and a civil justice system that garnishes the wages of something like 1 in 7 American workers may well be the most frequent touch point now between Americans and their government. And it's not going well. And so the work that we're gathered here to talk about today is not just about poverty alleviation, it's also about shoring up faith in government, and it's about shoring up faith in the rule of law. And I suspect, guessing many of you share my view, that there's going to be quite a bit of work to do on that front in the years to come. So thanks everyone for listening, and we can now turn to the panel. You're up. All right. So great set of panelists here. I think you've already been introduced, so I won't waste any time doing so now. But I am going to sort of focus on each of you as a point of entree to a set of issues and ideas. And I'm going to start with Verna. So I talked just now a fair bit about increasing the supply of legal help and reg reform. I even made fun of that as a political slogan. But from where you sit, what do you think is holding us back from increasing the number and the variety of ways to serve the legal needs of low-income individuals?
All right, thank you, David. First thing I have to do is to say thank you to David Wilkins and to all of his colleagues at the Center for the Legal Profession. They've done an amazing job taking an idea, a seed of an idea, and blooming it into this wonderful thing. And thanks to Kelly, also, my partner in crime here. That's metaphoric crime. Just to be clear, in case anyone is listening. Okay, what about the people? At Equal Justice Works, we are all about mobilizing lawyers to get out into the public interest world. To use your metaphor, we are mobilizing the firefighters to get them out there and working hard to get as many firefighters or attorneys out there to public interest organizations. And so I'm coming at this from our perspective. We've been around since 1986. Since that time, we have had 2,700 fellows. We've worked with over 600 host organizations, and we partnered with over, 350 law firms and corporations. You can see from this, the success we've had is based in large part on collaboration. We work with maybe unlikely partners, but what we all share is a dedication to access to justice. And so it's from this perspective that I think we can have the most impact in shoring up the numbers of folks. In a main way, I think the time is right for, I'm not supposed to say this word, but a movement. A movement. I was, and by that, I mean, I recently was at the Edmund Pettus Bridge, commemorating Bloody Sunday, and thought a lot about John Lewis and others put their lives on the line and how successful they were, obviously, in actually moving us toward a real democracy. Where's our movement? We need to coalesce. This convening, I think, is the beginning, can be the beginning, it's our decision to build a movement around civil justice reform. And to do that, we've got to, or some of the things that we might focus on, the barriers to public interest law. First and foremost is the money. Law school debt, I mean, the average debt, what is it, $200,000? At this school, it's a lot more, or the school across the street, I believe is what you called it. And the debt that students carry is enormous, particularly students of color. So when they graduate, they may come in with a desire to do public interest work, but by the time they graduate, the debt load is so enormous that, they have to do something else. So we've got to deal with the debt. We have to deal with the fact that we need to focus our attention on encouraging the students to do public interest work. The difficulty in that area, though, is what's happening now. If the students look around and they see mass layoffs, they see threats to the public service loan forgiveness program, we lead a coalition to protect that. It makes them think, many of them say, it's maybe not a good idea for me to do this. It's maybe not a good idea for me to do this. So we need to help them in that regard. The law schools, one of the things we've seen across the board with law schools is there's a great diversity in terms of the type of support that is available for law students. So students at a place like Harvard or NYU, they're available, they can get lots of advising about how to do public interest law, but not so in many state schools. So we need to make that more uniform. So that's just focusing on the lawyer part of it. I also happen to be a believer in broadening the field of people who provide assistance. And so to that end, we've got to encourage young folks to go into law. And we are partnering, or we're hoping to partner with Frontline Justice on promoting community justice workers, whether they're through the Alaska model, that Nicole Mason knows so well, and is the moving force behind, but also all of the different things that you identified. And I guess the last thing I'll say is, focusing on the root causes that we talked about at the first part of this gathering. One reason perhaps that this we have to connect more clearly the economic precarity that people are suffering, the fact that people work a couple of jobs, that they're just one step away from a disaster. If something happens, a divorce or a hurricane or something like that, the dominoes start to fall. This may be our moment to mobilize around that and connect access to justice, economic equality toward the end of improving our legal system. So I'm proposing, I think, a movement for civil justice.
Mm-hmm. All right.
And I say yes to everything else. I'm an improviser. I do improv. Yes and.
Love that.
Yes and. We need it all. It's an all hands on deck, and there's multiple decks.
Mm-hmm. All right. Let's stay on law schools for just a minute because we have someone who runs the American Association of Law Schools who surely knows a little something about what the law school role might be in all of this. So, what do you think? Did anything resonate there? What else do you think law schools should be doing?
Well, I think, first of all, I'm going to join Verna's movement, and I think all of our students are too. So I can tell you as the leader of the Association of American Law Schools, I get to work with all the law schools nationally. Before this role, I worked with the Law School Admission Council, where I saw clearly who was coming into legal education, what students were wanting to get into law school. And the good news is students want to do this work. That is not the problem. And, every dean I know has students who want to do public interest work, and there aren't the jobs that they can support that. And so the student demand is there, the job market, not necessarily. And it isn't that there is not a good match right now between the number of JD required jobs and the job market. The enrollments in law schools right now and the job market are pretty well matched. So, we saw a slide this morning about the steep decline in funding for legal services organizations and many other public roles. And so that has decreased the supply of paying jobs that are out there. But it was really interesting to me, and this fact I think will interest you, that about 5 years ago, the reason why people go to law school really started to change. For decades it had been, my family was in law and they thought I should do it, or it was, I think it's interesting and challenging, or I think I'll make a lot of money. The top 3 reasons today that people go to law school are all about giving back and doing good and working for justice. They may be phrased slightly differently, but that's the theme that's there. So on the good news side, we have the demand, I think, in our law schools. A couple things that I think we're going to need to consider, though, because if that's true, it's not enough to say, well, they want to, but there's nowhere to go. What do we do about it? And I think that one of the things that we do have to continue to work on is thinking more broadly about who can do legal services throughout our nation. I was part of one of the first efforts of this in Washington State when I was dean there to do the limited license technicians but it got sunsetted in Washington State. And so I think that we are going to need to make sure that we're not always having to go through the eye of the JD educated lawyer to get any kind of legal service. the problem's too big. And so that's something that I'm hopeful can grow. I see a lot of states, moving in that direction. And the good news about our law schools is they're ready to meet the demand for educating those professionals. Our law schools across the US have really changed from places that just do JD education and think about themselves as only educating lawyers to much broader institutions that think of their role of teaching law more broadly. And so there's a lot more master's degree programs now. There's a lot more ways to get educated about law. So I think our law schools are suited to meet the kind of educational requirement and licensing requirements that would come from that. And I see the deans, eager to step up and to work in that sense. And then the last point I want to make is one of the things that always is very popular is to say, well, the law professors just ought to teach more of this or that or something else. And I just want to say, we can do that, but it's unlikely we can do that faster or for less money. And so given that the debt problem is so big, we have to really think about that, because law schools are being called upon, first of all, to take students that are less prepared and to do more and more and more with them in 3 years. So there have been calls to not only make sure they pass the bar in the first try, they have more skills education, because postgraduate training has really fallen off out in the profession. So we've had to add many clinics, experiential activities, do more professional ethics, make sure there's business literacy, make sure they can market to clients, technological literacy. And that one is one from your talk where I think we're going to have to keep being really creative about the technological literacy of lawyers and law students, because it's very uneven, as you can imagine. And I do agree with you that technology is a one-to-many solution that can often help us leverage existing resources. And so that's something we'll have to look to too. So at least a start for what's a very big conversation.
All right, shifting over to Dan. Dan, you might be the Swiss Army knife of the panel, right? Because high-level service at DOJ, thinking about this stuff for a long time, I feel like you have that synoptic view of this whole landscape. So suppose this isn't improv. Suppose it isn't a yes-and world, but rather a world in which we have to decide where to put our political and real capital, and of course that's finite. So what do we do?
I think I'm supposed to represent the man on this panel, but I do want to just, before I start, I just want to double tap on one thing that David raised, that also Professor Furman raised earlier, which is that a lot of people in this room, I know, have been banging the table about the fact that our failure to close the access to justice gap was actually going to be it was going to erode the social contract in the country, right? Like, if people would lose faith in the American enterprise, they would say, look, if the system's rigged against me, what's the value of the system? And I know people in here have been saying this for as long as I've been practicing law. They've been pointing this out and saying this, and I think that a lot of what is coming today, I think it feels a lot like a sad validation of that feeling, but also all the more urgency, I think, for us to try to galvanize movement on some seemingly intractable problems. But to the point about where do we put bets, I've always thought about access to justice in the lens of, I think, like the Peter Singer style, thought experiment, which is you're walking by a lake, you see a bunch of people drowning. It's a boat is capsized, thousands of people are drowning. You and a few buddies are walking by the lake. Like, surely you would start pulling people out of the lake. But you're not going to get all of them, that. And so what would a sensible person do in this? It's very straightforward. You'd probably have some people pulling people out of the lake. That makes a lot of sense. But you'd also send somebody or maybe several people out to get more help, right? And to find, another boat who could come and capture up a lot of people or whatever. You'd find other solutions at the same time than just the pure, let me help you with that eviction case. You'd still be investing in some scalable solutions. And I think that that's exactly the approach I would take. I don't think it's particularly surprising, which is a diversified portfolio where you've got to be investing in and creating space for scalable solutions that I think is actually completely consistent. I know there's been this tension in this space around this, but I think that it's entirely consistent because you then can take the limited number of people you've got and you can deploy them at the hard problems, the bespoke cases, and then have scalable solutions deal with commoditized kinds of matters. And one of the things that I've had the pleasure of doing in my role at DOJ was also to connect with industry and through the Corporate Legal Operations Consortium. The slide that David showed about all the legal tech boom, which is very real. I mean, the last 7 years has probably been, it's crazy. There was a conference in the Clock conference last year, a legal tech company who did a very niche thing around data analytics, around contract lifecycle management, bought out the billboards on the Las Vegas Strip during this conference. And that's a sign of how much interest and energy there is in legal tech. That's going to the high-end consumers right now. It's absolutely going to the high-end consumers. But I think that the mindset that they bring there in industry is very much if it's commoditized, if you're doing a non-disclosure agreement, which we do thousands and thousands of non-disclosure agreements, they pretty much all look the same other than maybe some tweaks. We are not going to pay a lawyer an hourly rate at $500 an hour to do that. We are going to have an automated solution to drive that work. And then we're going to spend that $500 an hour lawyer at stuff that we think is higher stakes and actually also trickier. And I think that's got to be a key part of the direction we go in.
Great, thank you. Ben, I'm going to turn to you in a moment, but first I'm going to ask either Verna or Kelly, do you have a view on where we spend scarce political or real capital in this space? You don't have to.
Oh, go ahead. I know political capital is scarce. But I can't help. I grew up around the civil rights movement, the women's rights movement, LGBTQ movement. There was no political capital there. That didn't stop them. People will tell them, oh, slow down, Black people, why so fast? Like, well, 1860, seems like it's not really that fast. I get it that there's political capital that is in limited supply, but I also think that the current moment that we are in provides us with a unique opportunity. It's a crisis we can leverage. Because let's face it, the legal profession is under attack. It's an existential problem. Why are we here? Is it just a business? Isn't it a profession? Aren't there ideals? Weren't we trained to do something, not just represent people that get, the higher dollar, but we're supposed to be, doing something about benefiting society. So I think, notwithstanding the lack of political capital, I think we leverage this moment. And I guess my point, and the point I was trying to make, is that there's so much that's happening. I mean, what I've learned in the last couple of years is that there's an enormous amount of things that are happening to advance the ball around access to justice, but they're happening in silos. We don't always know what each other is doing. Why not come together and come up with something or some vehicle that allows us to know what each other is doing and bring urgency to the problem? The house is on fire for so many reasons. We've got to lift that up, and I think it is that way, that maybe we build political capital for it. It becomes the kind of cause that you can't afford not to pay attention to. That's how I think about it.
Mm-hmm.
I would agree with you. I think one of the things that I find very frustrating a lot of the time is how many conversations are happening without connection to one another, so that the energy it's less than a sum of the parts rather than more. And so trying to find ways that while we're individually pulling people out of the water, we can also be building structures that can bring people together, and scalable solutions, I think, is really critical. It's very disturbing to think that one of the largest enemies of some of the the more limited licensed professionals have been legal services organizations. That certainly was the case in the state that I worked on. I also understand that's very related to our prior panel talking about scarcity. You know, the idea that there's only so much focus and funding, so if we don't argue that it has to be served by a real lawyer, then there won't be more funding for us, and therefore, so I think that's some of what we really need to try and, you know, get people together on, but that's a tough one, and you know, it's not that a lot of people don't try, so.
All right, Ben, you've been very patient. So let's talk technology for a moment. So I made a pretty strong claim that courthouse AI is where the action is or should be, and that maybe legal tech, you know, won't pan out because of market economics, whatever it might be. And just as the fabulous Nicole Nelson will explain to me after this, or maybe in a question, why community justice workers are in fact more scalable than I suggested. Be interested to hear that. You're now going to tell me why I'm wrong.
I'm not sure I'm going to tell you why you're wrong so much as why I think we might need to look at it from a different angle. So first of all, I just want to say thank you to everybody who is even remotely interested in hearing what I have to say. I look around the room and I think everybody in here is smarter and more accomplished than me. I kind of feel like Forrest Gump walking into the White House and telling Lyndon Johnson he drank too much Dr. Pepper. So it's an honor to be here. Really interesting question. So we have this framing, right, of these three potential problems or solutions to the problems. Create more lawyers, make the system easier to access, and whatever the middle one was, I always forget what it is. I have a pretty high degree of conviction that access isn't the problem, which is why I've kind of stopped talking about access to justice when I talk about what it is that users need to move ahead, or I call them users in upsolve space, but what it is that low-income Americans need to move ahead. And here's the reason I think this. Upsolve has 3 million people per year that come to our website. They read really well-written legal content, often written by lawyers, that gives them education. So we've solved for the education piece of the puzzle. The access piece of the puzzle is, can I now take action on this content, what I've learned? And so we've built a really, really simple tool that has a really high success rate to move people through the bankruptcy process. Here's the problem. Of that 3 million people, only 1% actually start our tool. Okay, so you have the vast majority who never develop the conviction to start taking some legal action. Of the people who do start, those 30,000 people a year, only 10% of them actually finish their bankruptcy application and go on to file. And this is not a function of the tool not working well. When you file, we have a success rate that is actually better on average in the country than working with a paid attorney. And, you know, that's a great thing, right? It's a great thing that people can get out of debt and solve this 118,000 wealth differential that filing bankruptcy versus not creates in their lives. But what is that gap? Why is it that when you have a tool that a lot of people are starting to access, no one does anything? And I think this is a lead a horse to water kind of problem. You can give people these resources, but unless you can give them the additional push to build conviction to take action on them, they don't use them and nothing happens. And so where I disagree with you is that if we make the best functioning court system in the world, it's still scary, right? Like, it's still scary to go to court. I went to law school. I'm still scared to go to court. I don't ever want to be in court. And the average consumer who has, 2-3 jobs, who is being sued for eviction or being sued by a debt collector who's calling them all the time and screaming at them, telling them they're going to lose everything, they're scared of going to court, and they need some hand-holding, some human guidance to move forward to take those actions, even when they understand what those actions are. So I don't think the problem is access. I think the problem is conviction. And so if we look at this create more attorneys or create better technology paradigm or create a better court system that's just less complicated paradigm, yes, I think what we've been able to do with legal technology in the past has made it easier, but ultimately what has to exist for conviction to develop are humans, lawyers who understand the processes, who can sit with, let's say, Dan when he comes in for an hour, 2 hours, 3 hours, answer his questions, explain the process, walk him through what's going to happen. Maybe he leaves the office and comes back in a week and says, okay, now I thought of this new concern, tell me what's going on with that. And the reason I know that that works better is because that's what happened with me, right? Like in 2016, I had a business that failed. I had $60,000 in debt. and I was making $20,000 a year driving for Uber and Lyft, right? I was stuck in this process. I found out about bankruptcy, and it still took me 2.5 years to even file, because I was terrified I was going to lose my car, couldn't drive Uber and Lyft anymore. I was terrified that my dream of someday going to law school would never be realized because no state bar association is going to take me if I filed bankruptcy. And even as I started on the process, I kept hitting these hurdles of fear that kept me from moving forward. That conviction got blocked. So it was, did I do this form right? Is this for the right state? I don't know. Literally, I would say 6 to 9 months of back and forth on this. And it wasn't really that complicated of a process, to be honest with you. Like, you're filling out forms, but they're fairly straightforward if you can find the right ones. It's overcoming those fears along the way that takes the advice and guidance of a person. So I'm coming to a very, hopefully a succinct answer to your question. Historically, what we've done when we've tried to solve access to justice problems with technology is we've said, okay, who's the service provider that tends to provide that wraparound conviction and process support? In legal services, it's lawyers. In financial services, it's financial advisors, things like that. What things that they do can we automate with technology? So TurboTax, for example. TurboTax is not a full stack, tax preparer. They are a person that can do very simple tax returns, or a function of doing very simple tax returns. And that's what the tech has, generally speaking, always been. That is not the world of technology that we're in anymore. We are in a world of technology now where we can go on ChatGPT, and I literally did this on the way here today, and say, hey, your role is to be an agent, to be a tax preparer. Here are the rules that you should follow. Here's the way that you can talk to a consumer. Here's how you can look up data. Here's the data set that you would use. And you can spin up something that works, sounds, functions as well as a general purpose tax preparer that can answer questions from a consumer at 3 a.m. when they're worried about, oh, did I put the right thing on this document? So we're now in a world where we don't have to scale individual services, but we can actually scale almost all of the functions of these service professionals, specifically that conviction building piece. I have an AI model right now that you can text at 3 a.m. and say, hey, if I file bankruptcy, am I going to lose my car? Oh, I'm not? Great, I'll go to the courthouse tomorrow instead of dropping off. And so in this paradigm of, do we make the service easier to use, or do we make more technology, or do we make more lawyers? I'm contending now that technology can actually make essentially an unlimited supply of lawyers, at least as far as conviction building goes. Now, there are restrictions to that, what we can and can't do. Obviously, all of us have functions and purposes that go beyond what a tech can do. But I think we can actually solve that conviction building piece with tech, and I think that's the bigger problem for access to justice.
Jump in.
Well, just to add, and I don't really have an answer to this, but it's something that I've been observing, which is that I do think that generative AI has lowered the entry point for a lot of things. 5 years ago at the Justice Department, I met with a legal tech startup, and they were doing something basically around how can we help you with technology that would help you do RFPs, like requests for production. And it'll help you automate, but also uniformize, is that a word? Make more uniform RFPs that we're drafting thousands and thousands of these every day at the Justice Department. And so this legal tech startup said, well, we can build this and we can tune this for your specific kinds of RFPs. And they said it'll take us a couple $1 million. It'll take us a couple years to do it, but we'll get there. We'll do it, and it's going to work pretty good. It's going to work pretty good. And then fast forward a year later, and I had a grad student here at around the corner, who called me and said, "Hey, I've built this tool that gives you an analysis of redline documents, and it can do it. It does it really, really fast." And I looked at it; it actually did it really well. And he said, and I asked him, "How long did it take you to build this?" And he said, "It took me about a week, but it was like at lunch breaks between classes." And that was a totally different deal. And I think, but the reason that this is relevant to this conversation is that, and I don't know the answer to this. It's just that whereas before the regulatory barriers presented a real threat to investment being willing to put in on startups that were gonna take the plunge, because it's you're asking me for millions of dollars and it might not pan out because there's all these rules you're running up against. I think now, because the price point is so low, that you're gonna see more people just frankly take their run And whether it succeeds or not, the cost is so low that they're going to take their run. And I think we have to grapple with this now, is my point. We do have to grapple with what Ben was describing.
Kelly, I saw you wanted to get in.
I was just going to say that another use of technology that I'm interested in is how it can help us sort of train the trainers and train the lawyers. Yep. In the sense that Chief Justice Gordon MacDonald is here from New Hampshire Supreme Court and has been leading an effort among the Conference of Chief Justices to think about practice readiness and bar admission. And one of the things that we've noted is just that the kind of mentoring post-law school is really much more absent today. And we all know that the arc of a lawyer's development is over a long time, not just in law school. And so one thing that strikes me is there a way to use technology to try and help bridge that moment? And it could be very effective because even though there may not be enough public interest jobs out there, there's a lot of rural practitioners, solo practitioners, people who, if they were more comfortable, might be able to serve more clients. So that's one area that may be a hopeful one. That's not quite mentioned, but it's very similar.
I mean, I think there's something to be said for that. Like lawyers armed with the power of, say, an AI that's a paralegal are tremendously more effective, especially if they're learning a new practice area. So not legal per se, but the other day I had a huge data analytics problem. And I went to law school because I don't want to think about numbers, right? And I said, hey, can you teach me how to do this to a ChatGPT model? And you go through an iterative conversation and you end up at the other end 20 minutes later with an answer on how to do it. And that level of personal development, access potential to do things like you're talking about is incredible and unprecedented and really should be something we talk more about in law schools.
Art, I knew this would go fast, but we're coming down the home stretch, and so it'd be great to take the pulse of some folks out there. So I think maybe if we have the same set of microphones going around, if we could maybe get a couple questions from the audience. We got to start with Nicole because I already called her out.
So I'm Nicole Nelson. I'm the CEO of Frontline Justice, and we are an organization that is mobilizing and empowering a new category of legal helper, the justice worker, as a solution to this access to justice crisis. And so a couple of things I am curious about. David, I think your idea, or your throwing your chips in making using generative AI to make courts more accessible and friendly is good, but it ignores the research that shows that most of the problems that people are facing never reach the courthouse steps to begin with. And so I think that's something we need to be thinking about. I also wonder, when we think about this idea that, I love, Verna, this idea that we'll build a civil justice movement to bring things forward. But I think one of the problems with respect to that is when we're thinking about access to justice and getting it to catch on, and get the general public to think about protecting the rule of law, we have excluded them from the practice of law, and in 92% of low-income people are living outside the protection of laws. So they're not going to rise up to join us to help us protect the law because they've been divorced from it for a very long time. And so one of the ways that we could do that is encouraging more people, more helpers to come to the table and thinking about ways that we can do so in a very low barrier way. I love the idea of law schools thinking about how we can encourage different pathways to those who practice law, but what about community colleges? What about making law more accessible in the places where people already are, and marrying that with technology, as Ben has said, to help people get the conviction and the accompaniment they need to actually make the choices and enforce the law.
I think Verna has volunteered to answer that question.
Oh, it's not even, I mean, I hear you 100%, Nicole. And when I talk about a movement, I mean, I'm thinking also that part of this is, if we want to do movement lawyering, we have to go to the community. We have to engage with them. We have to learn from them. We have to use techniques like participatory action research to learn from them. So I think I hear all of that and I see all of that because I also agree that, I mean, most people don't know what rule of law is. Most people don't understand, three-part government. I mean, there's just so much to be done. But I think that if we set our minds to it, we can. Yeah.
I'll just tell one very quick story, and that is I was once in a meeting of a president and provost and the deans from all the schools and colleges, and the question came up about whether there should be some initiative around justice. And what the business school dean said, "Why do we need to worry about this? We have a whole school devoted to this," at which point I thought he meant me in the law school. He said, "The school of social work." So I think that, but we should be building those bridges. And today, we have a lot of our law school deans. They're all sitting right in the middle here with us today too. A lot of law schools are really teaching more at the undergrad level, bridges with community colleges, a lot of initiatives. And so I think there's a lot of energy in legal education for your thought there.
I love the idea of bridge building, but I always get worried that bridges are going to be blocked by UPL, right? Like if we find new people that can go out and educate people on their legal needs or, help them build conviction, okay, are we now going to sue them, right? Like, if you asked earlier, what's the thing that's the biggest barrier? I consistently feel like it's UPL. There's 100 million. Oh yeah, sorry, for those who don't know, unauthorized practice of law. I mean, there's 100 million people in the U.S. who are below 200% federal poverty level. They have on average $197 of discretionary income. The average lawyer costs $341. Like, there's no access. They're not going to be able to get access from these people. We have to have more people who can give legal advice and build conviction than just lawyers, or this never gets solved.
This also goes back to the point that David was making, Wilkins was making earlier about the legal profession having to reimagine itself. I mean, part of the problem here is that the legal profession has been kind of static. We rely on precedent. We don't like change. And to be fair, there's a concern about protecting the public. But the problem is, in protecting the public so much, the public is at risk because they're not getting the representation that they need. So now is also a really important time for us, as David was saying, to reimagine what it means to be a lawyer.
So I have a question. Sean Scott, I'm kind of here in two capacities. My day job is as the Dean of California Western School of Law. I film the rest of my time as co-president of the Society of American Law Teachers, which is the only association that actually represents law faculty. So as I listen to the conversation, it does seem to me that a piece of the conversation has to be about whether we as a society think that people who don't have access are worth serving. I think fundamentally we believe that if you can't afford it, it's because there's something wrong with you and you don't deserve help. And so I think about this concept of access to justice. And fundamentally, like at the core of all of this, seems to me to be issues of race and socioeconomic status. So and that I think kind of ties into your idea of conviction, right? There's shame associated with filing bankruptcy. What is it that I did wrong that put me in this position? And not filing for bankruptcy kind of allows you to avoid what you think is that fundamental question about your self-worth. I don't think we think that we are worth saving. And so when we think about movements, Verna, I think about the fact that we are here, and you and I had this conversation, and I think about Professor Bell, and I think about his concept of the permanence of racism and maybe the permanence of inequality. And it's really heartbreaking, to kind of think, damn, was he right?
Here? I could. So I just wanted to say, this is David Udell, National Center for Access to Justice, but while Verna was speaking about movement building, and by the way, I don't want to take anything away from the profound comments that were just offered, but I did want to say that I consulted with ChatGPT using my phone, and I'm happy to say that there already is a very active civil justice movement, a reform movement. So I think that pretty much answers that question. But on a separate point, the point about conviction and what does it take for people to become motivated to assert their rights, I wanted to submit that maybe the problem is that the law itself is very unjust. And so, David in his affirmative remarks spoke a little bit about the category of procedural law reform and the restatement. But some of the law is substantive, and it's very unjust. So the amount of money that you can put aside when you're being pursued for debt and garnishment is very tiny in many states. The bankruptcy rights have been reformed, and I'm no expert on bankruptcy, but multiple times to make it more and more difficult to qualify for bankruptcy. And so anyway, my shop, we have a justice index where we track the laws across the country. We rank the states, procedural and substantive. But I really think our access to justice movement focuses way too much on access and way too little on justice. Injustice is bound up with what the substantive law is. And I think it should be a priority for us, particularly because there are going to continue to be inroads made against fairness in the content of the substantive law.
I think that comment fits so well with the one that Dean Scott made, too. It reminds me of Gilmore's quote that in hell there's nothing but law and due process meticulously observed. Just to really focus on where the justice. Where is the justice? Yeah.
I trust that the powers that be will cut us off when it's time to end, but okay, I thought so, and I think we now have a question here, so.
It pays to have gone to the school across the street, but anyway. My name is Fern Fisher. I'm a retired judge, so I see the world from a lot of different perspectives. But right now, I'm the executive director of Legal Hand, which operates call-in centers throughout New York. We're about to open one in North Carolina. And let me say that from our experience, the conversation is going to change because the people that are calling us who cannot afford lawyers are not just low-income people. They are more than moderate-income people. Firefighters, teachers, correctional officers, so forth and so on, who, even if they could afford an attorney, they can't get an attorney that will do the small kind of cases. So I think that's going to change, but if we don't address that issue of the moderate income, the middle class being, distrustful of the court system and the justice system, we really are going to have a problem, really seriously have a problem. The second point I want to make is, and I agree with Nicole, is that we have to expand who we use. So in 2 years, we served 12,000 people using community volunteers, some who were formerly homeless, so they really know, the guts of what goes on and what happens to people. College students, community college students, and law students. And together, we have been able to give confidence and to empower people who have no other choice but to go into the courts themselves. The third point I want to make is that the most affordable thing is to change the courts. All right, so when I was the chief judge of New York City, we did a lot to change the court. But that's not happening all over the place. So, I now see other parts of my state where the forms are ridiculous, or there's no fillable forms, or they're not in plain language, they're not in different languages besides English. Those are the simple things to do, and it doesn't cost the court system to do much. Training of judges to be more proactive, neutral but proactive, is simple. And that could make a difference. I mean, there's so many, as David, right? David said, it's a patchwork. It's a patchwork. But to me, the simplest thing is change the courts. Change the courts. Simplify the courts.
Hi, I have the second mic, sorry. My name is Eduardo Gonzalez. I'm currently the interim executive director at the New Law Lab. My question is on sort of thinking about the vision of justice problems and people going through our courts. Oftentimes we see sort of legal problems or legal cases as a barrier that gets in people's way, but these aren't sort of things that we discover out in the wild, right? Law happens to us, and so it feels like it's a weight on every individual that has a legal risk or problem. And what I've sort of been trying to grapple and work with is how, when we alleviate those the weight on people's sort of legal risk and precarity, what happens, right? And the goal, I think, in my mind, is to attach it to our vision of participating in local government, understanding how to go to your city hall to actually sort of talk about the kind of case or laws that are being considered. But when people have an eviction case or they have civil legal problems, they're not even thinking about engaging in their civic life. And I think that's where we build trust in our community and our institutions. And so I wonder if the panel could sort of grapple with that connection with me about how do we reframe access to justice as alleviating or securing citizens' ability to participate in their community, so that we don't really focus just on the legal problem, the legal cases, the lawyer, but more focus on the community as a whole and its well-being.
I'll offer one quick thought, and that's just that it reminds me of Martha Minow's point about how people's distrust of government and institutions has become so high. So I think it's part and parcel of that, and that there's somewhat of the reason why law is so distrusted is it's seen as a government force against, policing like power. And I think, so building that understanding of why government is a good thing that can actually help people. And, I think so much about our language needing to really shift to being about helping people, that's why we do this. It's about helping everyone thrive. And trying to talk about it in simple ways and how the different components can do that. But I agree with you that meshing needs to happen.
Yeah. We have time for one more.
Okay. And hi, I'm Catherine Alternator. For 10 years, I led the Self-Represented Litigation Network, so I'm all things pro se. I have a very concrete thing to end with, and an infrastructure thing, and maybe where we invest some political capital. The technology investments that we are making, they're not going to go anywhere if the digital divide is not addressed. So we are building trains, and the train tracks are being pulled up. And so I think that's just a policy thing. Everybody who works in this space needs to watch. At the end of the Biden administration, there was a real pullback on funding, that subsidies that had gone into place for digital, and it's only going to get worse. So everybody should educate themselves about how digital is being, the digital divide is being addressed, the pullback on libraries, but it's not just do you have internet, it's speed, safety, all the things. So very concrete, infrastructure.
Listen, this is the beginning and not the end of a very important conversation. Before I welcome our last and a really critical speaker who has made all of this possible, the president of the Academy, please just thank this incredible panel and David for framing these remarks. Please, you guys, you don't have to sit here anymore. Thank you. It is a conversation that we will continue tomorrow. For those of you who are able to join us at that other law school we keep referring to, which is around the corner, and where Verna and Kelly really have convened a really terrific group of people who will themselves just be beginning a conversation. I just want to say before I bring Lori up to close the conference, first just to thank my incredible team who you've seen run around with the microphones, but also at the tables and everything else. That we are a very, very lean but mighty team of 3 other real workers who mostly their job is to make sure I don't screw up, and that's Brian Fong, who's sitting up there, please wave, who's the executive and research director of the center. Dana, where are you? Oh, there you are. Dana has been she's our lead writer for the practice and also coordinates all of our student engagement and our media on messaging. And then Tashana, is Tashana still here? Tashana Santos, who has the hardest job of all of keeping all of us running on time. But without Dana, Brian, and Tashana, none of this would have happened. I'll just close what I want to say and then bring Lori up by ending where we began, which is, There are many, many amazing things we've talked about here, but the three core things that Jason started us off with, which is how do we understand what the facts on the ground really are? Then how do we frame narratives to talk about those facts in a way that is empowering and not disempowering? And third, how do we use that to both mobilize and reinvigorate our institutions of government, of which the courts are one but only one, and civil society to reinvigorate and reinvent and reimagine the deep conversation that was started in this by the people who started this academy at the birth of what is now going to be our anniversary year. That is critical, that is difficult, that takes hard work, and it takes people who are willing to convene us. And Lori Patton, the president of the Academy, is best suited to talk about how we might take this conversation forward. So please welcome our real host, Lori, to the table. Thank you.
Thank you. I don't know what's worse, being between people and dinner, being between people and drinks, but I am between people and drinks. But thank you, David. And I just wanted to say hello and share a couple of even more meta thoughts than the meta thoughts and the concrete thoughts that were just shared this afternoon. It's a true privilege to be here at the House of the Academy with you for these important conversations on inequality, access to justice, and the rule of law today. I want to thank David for organizing today's events, along with Verna Williams at Equal Justice Works. I know you are going to be continuing the conversation tomorrow, so it feels really good to sort of launch it here. And I also want to say a huge thanks to Martha Minow, and she's going to be coming in and out, and John Levy for their contributions to this work and their leadership at the Academy on access to civil justice that has made this such a fruitful gathering for everyone. As I'm new, I'm also the new person that's helping with sort of the final stages of certain projects, and so I was privileged to be at the conversation where we're thinking about wrapping up the Academy project in this space. And it was really moving to me to see the bonds of affection that have resulted because of this work that feels personally as well as professionally meaningful to so many of you who have worked on it, as well as the people in the room. I also want to take the time to acknowledge our Academy staff, some of whom you might see in the hallways. They are extraordinary. Laurie McDonough, Kristen Josty, Alan Johnson, Zaki Klieger, and Betsy Super are here and around today, and also Eduardo Gonzalez, who contributed so much to our work. It's really wonderful to have staff with us here. You probably heard, many of you, either today or in other contexts, words from my colleague and good friend, Goodwin Liu, a board chair, on the Academy's work on civil justice over the past few years. He does feel badly that he couldn't actually be here in person. But I wanted to go back a little bit further and note the thread between that work, the ideas that bring us here together, and the founding of the Academy, which David has mentioned, as an organization started in 1780 for the purposes of, quote, cultivating every art and science which may tend to advance the interest, honor, dignity, and happiness of a free, independent, and virtuous people. It's a beautiful, beautiful mission statement. We quote it pretty much every day. We write it, we think with it. 2 points I want to make about that founding that may be helpful for you as you continue to think about questions of inequality and access to justice. The first is in 1780 was the worst year, arguably, of the Revolutionary War. Benedict Arnold revealed himself as what he was. We had the worst military defeat in the Battle of Charleston, and all over, including Washington's troops. American troops were starving and eating stuff from the ground. It was really hard. And yet, the folks who gathered in 1780 simply to share knowledge and think about what democracy was, did so in the midst of all of that. And I would submit here that gathering at all is one of those things that we must continue to do, perhaps particularly when the disincentive to gather is so great. The second thing that I want to name that seems important, and when I share this, I've shared this at the induction where I was incoming president this past October, and continue to share it at all of our local committee meetings around the country. We've had the privilege of visiting folk academy members around the country, is that every single one of those words in our statement, interest, honor, dignity, happiness, free, independent, and virtue, have to be rethought and are contested now more than ever. What is honor in an age of insult? What is dignity in an age of catastrophe? What is independence in a time when we all feel a moral need to study and enact interdependence? There's so many different ways to think about this. And every conference I'm at, like this one, I wonder about how the conversation can help redefine those words for the mid-21st century. And I must say that this afternoon's conversation, when I think about interest and honor and dignity, there's nothing more compelling than access to justice and inequality, to redefine those words. That's how important it is for us to continue this conversation. I would also say more generally, now as then, we need every art and science, including legal thinkers, legal practitioners, educators, civic leaders, and public servants to ensure the rule of law, to define it, to make sure people understand what it is, and to find new words to describe what we mean by it, the pursuit of equality, and the realization of access to justice, and share those stories of success where we find them. In the early days, that meant while John Adams was founding the Academy, he was also defending British soldiers on trial for the Boston Massacre. He knew that that movement and that action would communicate more in that moment about the rule of law than any other thing. I don't know if that would be true today. And that's something I think about all the time as a non-legal person. He also knew that ensuring educational institutions were free to pursue their missions and govern themselves as private educational institutions for the public good, as Daniel Webster argued some years later, that this too was crucial. If you look at, as I've had the privilege of doing and writing something about our current moment on behalf of the Academy, at the state constitutions in Pennsylvania, in Massachusetts, in Kentucky 30 years later, all of them had deep legal and important philosophical arguments about education that ended up also being deep legal and important arguments about liberty. It is quite clear to me from having lived for a little bit as I travel from place to place in the early founders' documents that liberty and learning were mutual and reciprocal for our founders. And that matters today. And so bringing every art and science in support of democracy and the rule of law, as each of you do in your work every day, is also essential to my vision, our vision for the Academy. I wanted to share a little bit about where we'd like to go for the Academy, and then send us all off to our wine. The first is, there are 4 basic areas where I want to move us to celebrate something extraordinary in our own semi-quincentennial in 2030. The first is, as a result, but not exclusively as a result, we began to think about this before this election, of the chaos, the tumult, the arguments, the insecurity that people are feeling today, we are going to turn all of our work in our traditional areas in education, security, cultural institutions, science, and political economy, broadly speaking, toward their connection to democracy. Our entire focus for the next six or 7 years will be on democracy and how in each of those areas, what is the knowledge that democracy needs for science? What is the science knowledge that can be contributed to our democratic living together? How do we think about democratic processes as helping or hindering security? How can we think about economic participation and the transfer of wealth, for example, as both helping and hindering democratic freedom? And how can we think about the cultural institutions which are so central to critique, to envisioning a future as being essential to democratic thriving? That's our first priority, and we're very excited about it. Our second is we're going to be moving from just reports to something broader, to maps, to indicators, to blueprints for action, which several of you mentioned already this afternoon, so that reports aren't just the things that sit on the shelf that we have to find a relevance apparatus for, but rather that as we update our indicators, as we update our maps, they become their own engines of relevance. So I challenge all of you as you work in this area, what are the things that need to be measured that aren't being measured now, and how can we help? It's a very important question, and we'd love to hear from you about that as we develop new kinds of products from the Academy. Third, and this is something that Martha mentioned and many of you have also taken up, we want to learn from the power of the local. Not just the local as a kind of boosterist thing, but rather when, as I deeply believe, America can recognize itself still at the local level and share those local stories of success on behalf of the national narrative, which we so badly need. Are there stories of local success around access to justice that you could share, that we could help you magnify? I think it's an incredibly important thing to think about. And we're also moving with our local committees in the Academy. We'd like to move them from 17 to 30 over the course of the next 7 years to create a truly American Academy of Arts and Sciences. And to ask, as I have at the 8 that I visited so far, what is the local work that you want to do as Academy members, as thought leaders? And relatedly, are there ways in which we can reward and recognize young and older partnerships between generations and across religious, political difference to create local solutions so that in 2030 we could celebrate a local, exemplary local partnership across difference in every single state as a kind of AmeriCorps for thought leaders? It's an idea that we'd love your help on. And finally, to elevate the power of convening, which is where I want to leave you with tonight. We have been known, it is our mission to convene from an interdisciplinary perspective. And it's very important that we use that power to convene on behalf of the nation every step, which has meant I've asked my staff in the last 2 months to pivot from things which are super curated and careful to things which are still super curated and careful, but that operate at 2, 3, 4, 5 times the speed, which means every issue that comes up that we feel in some way or other threatens our liberty or our democratic purpose, we will gather and we will discuss. We had the first convening on Zoom on science funding and the crisis in science funding. Second one on constitutional crisis was public. We had over 1,000 registrants, about 500 folks come. Our next one is going to be on the limits of executive power, and it'll be in a couple weeks, so look for that. The other thing I want to share with you is that on April 14th and 21st, I'm swallowing hard, the American Academy and the Association of University Colleges, American Association of Colleges and Universities, is going to be gathering as many as have been invited, and all of them have been invited, every single college president and university president, to see if we can speak with one voice. We feel it is time for us to do that. I'm scared to death. I'm going to need your help. Those are incredibly important things that we feel we must do as people who are independent, not needing for our livelihood federal funding, and not lobbying organizations. So we will see. We may fail in getting the higher ed sector to actually speak as one voice, but it is very important that we will have tried. So I'll end by leaving you to ponder two principles that are core to who we are and the work we, this group, could do together next. I love what Verna said about rebuilding and reimagining. I believe that this moment asks not only for short-term tactics to preserve democracy, but also for long-term thinkers, because we will be asked, even if it's just next year, to rebuild and reimagine what democracy is, what it means to us. And that bringing people together in interdisciplinary ways is what our charge is. So please call upon us. If there are things in the legal profession that need support and engagement from outside the legal profession, technology, I heard, community activism, I heard so many different things, call on us. We can help you with that convening. It would be an honor for us to help you with that convening. And it also, I think, in convening, helps us do what Ben was talking about, which is build conviction. You were talking about it in a very specific, almost technical way, but I think overall, that larger activity of building conviction can only happen through convening. And the second principle I want to leave you with is related to that, which is I deeply believe that convening, the will to convene, is the beginning of democracy. And continuing to convene is its perseverance. Thank you very much and enjoy your evening.
Thank you very much. As you can see, the Academy is in excellent hands as we move forward. Thank you all for spending this afternoon. I hope you'll spend some time socializing and talking this conversation forward in our reception, and we look forward to seeing and being in touch with many and all of you for many years to come, because this is just the beginning. Thank you very much.